Thank you, everybody be safe. Commonwealth versus Sean Blakely.
Yes, okay. Yeah. Trying to read it. No.
Are you Sean Blakely?
Yes, sir.
Good morning.
Morning.
This is 26 CR 0051 for a pretrial conference and 26 CR 0062 for an arraignment. You have the right to remain silent. You're represented by counsel. The grand jury of Monroe County has returned an indictment charging you with trafficking a controlled substance in the first degree, first offense, possession of a controlled substance, first degree, second offense, expired plates, carrying concealed deadly weapon. Operating motor vehicle with one headlight, possession of drug paraphernalia, being a persistent felony offender. Counselor, do you acknowledge the identity of your client, received the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions. On the new indictment, I'm signing a reciprocal discovery order. It requires the Commonwealth to provide you with all the information they have to help you prepare for your defense.
I do, Judge.
What is the negotiation day that you have?
It's gonna be September the 4th.
September 4th. You to be here at 9 AM on September 4th for negotiation. The next court date, September the 17th.
Yes, Judge.
Okay,
Yeah, I thought we were talking about Monroe.
Joshua Geralds. Joshua Geralds. Come on around. Are you Joshua Geralds? Good morning.
Good morning, sir.
This is 26 CR 0048. Mr. Geralds, were you born in 1989?
I was.
Last four digits, social security number 3564. You're here on a pretrial conference.
Correct.
What do we have here, Counselor?
Judge, we're still working through this case. If we could get a negotiation date in September.
Yes, Your Honor. That's right.
Negotiation date on September the 4th. The next court date is September 17th. Okay,
Thank you, sir.
Thank you, Judge.
thank you. Curtis Bergen.
Probation.
Commonwealth versus Curtis Hurrigan, 26 CR 0040. Are you Curtis Hurrigan?
Yes, sir.
Good morning. You born in 1955?
Yeah.
Last four digits of your social security number 8106.
Yes, sir.
On probation revocation. What does the Commonwealth have to say?
Your Honor, we're needing to get some witnesses here for a hearing. So if we could pass this 1 month so that we can have the revocation hearing.
What, give me a little information about this.
Okay, Your Honor, this, his underlying case, was an assault on a nurse at the hospital.
I remember
And he
that.
was ordered, to, attend anger management. It's my
Yes.
understanding that he's been kicked out of anger management. So, and some other various places. So that's the reason why we're going to be asking for him to be revoked. And we were just needing some witnesses here, to testify on those facts.
And Your Honor, this is Ms. Hill's case. That is my understanding as to what it was going to happen today.
Is it what?
This is Ms. Candace Hill's case. She is currently covering
Oh.
a different docket,
Okay.
but that is my understanding as to what
Okay.
we were going to do. today.
17th then?
Yes, Your Honor.
Okay, see you then.
All right, cool.
Justin Hunt.
You're gonna find out.
Mr. Hunt, you want to come over? You are Justin Hunt. Good morning. This is 23 CR 0033. Were you born in 1980, sir? Last four digits, social security number 3108. You're on a probation revocation. What does it come up? Come on, let's forward just a little bit there.
Your Honor, I also believe this is Candace Hill's case. I don't,
Yes.
we're ready for a revocation hearing, but, Mr. Stockton would have been in agreement if Ms. Hill was wanting to handle this
Tell me
herself.
what the allegations are.
Judge, this case came up last month. He picked up a new felony that's currently in district court. I don't know what the felony was.
I think it's in Henderson County. It's
Yes.
in another county.
And he is scheduled for a preliminary hearing on that case, I believe either this week or next. So we were going to request to pass this in September to see what happened.
I have no problem with that. But I wonder when that's gonna be.
Preliminary hearing is actually today.
Okay.
They'll reschedule it because I told them I had court here today and they
Yeah.
said they'll just reschedule
Well,
it.
let's see if, let's put a negotiation day on September the 4th in case of preliminary, and that way we can move it forward and try to get you through the thing.
Yes.
September the 4th, negotiation, September the 17th, and you'll be responsible for a transportation order if we can use the 4th for negotiation, okay?
Yes, Sean.
Okay, thank you
Thank
very
you.
much. Mark Hunter,
He should be, so we're. He's playing.
Commonwealth versus Mark Hunter. Are you Mark Hunter?
Yes, sir.
Good morning.
Good morning.
This is 25 CR 0032 and 25 CR 0079. Mr. Hunter, were you born in 1977?
Yes, sir.
Last four digits, social security number 8597.
Yes, sir.
You're here for sentencing on these two cases. If you had an opportunity to look at the pre-sentence investigation report done by probation parole
Yes, sir.
and also the comprehensive sex offender pre-sentence evaluation, have you seen that?
Yes, sir.
Are these reports substantially correct, counselor?
Yes, they are.
Is there any reason this gentleman should not be sentenced today?
Not that I'm aware of, Judge.
Or plead guilty to sexual abuse, first degree, vulnerable victim, 3 counts, and 25 CR 0032. He shall receive a sentence of 10 years on each count to run concurrently for a total of 10 years. On a plea of guilty of distribution of obscene matter to minors, 25 CR 0032. The defendant shall receive 5 years. The two sentences shall run concurrently for a total of 10 years on plea of guilty of sexual abuse, first degree, vulnerable victim, 25 CR 0079. Defendant shall receive 10 years. The 10-year sentences in 3279 are to run concurrently for a total of 10 years. The Commonwealth will oppose probation. The 10 years shall run consecutive to and agrees to stipulate to revocation in 19 CR 00114 and 23 CR 0053. Is that correct? 53?
I believe so, Judge.
Yeah, there was interlineation there. Okay. Okay, well, you are in the custody of the Department of Corrections there. Thank you.
Thank you.
Yeah.
Say, Marty.
Ricky Lee. Ricky Lee. Commonwealth Kentucky versus Ricky Lee, 26 CR 0032. You are Ricky Lee.
Yes.
Good morning.
Morning.
Were you born in 1986?
Yes,
Last four digits, social security number 5412.
yes, sir.
You're here for sentencing. You had an opportunity to view the pre-sentence investigation report and information. Is
Yes,
it
sir.
substantially correct?
Yes, sir.
Counselors, any reason this gentleman should not be sentenced today?
If there's no reason, yeah.
Okay, upon pleading guilty to burglary, 3rd degree, 2 counts of offense shall receive a sentence of 5 years on each count to run concurrently for a total of 5 years. He had no contact with the victim or the victim's property. And there's some other agreements in there, that,
Yes, sir.
what are the court costs in this case? $220. You start paying that 30 days after you're released at $30 a month, okay?
Yes, sir. Thank you.
Very much.
Thank you. Thank you.
Caleb McClellan. Commonwealth versus Caleb McClellan. Are you Caleb McClellan? Good morning.
Morning.
Were you born in 2004?
Yes, sir.
Last four digits, social security number 9698.
Yes, sir.
You're here on 26 CR 00447, a pretrial conference. What does the Commonwealth have to say?
Judge, we've, I think, tendered an offer and we're just waiting to see if it's going to be accepted or if we're going to end up having to set a trial date.
So Judge, there's some updated information. I spoke with Mr. Stockton yesterday. We are still actively working on negotiations. In this case, there is some updates that he and I have been discussing, and we had discussed passing it to September.
September the 4th, negotiation day. September the 17th, next court date. You'll be responsible doing transportation order.
Yes, Your Honor, thank you.
Okay. Joshua Perry. Commonwealth versus Joshua Perry. 22 CR 0033. Are you Joshua Perry?
Yes, sir.
Good morning.
Good morning.
You were born in 1991.
Yes, sir.
Last four digits, social security number 5880.
Yes, sir.
You're on a shock probation revocation. What's the Commonwealth have to say?
Yes, Your Honor. Mr. Stockton has agreed to pass this 1 month. I believe defense counsel is trying to obtain some type of proof to see if he was incarcerated during the time period that a warrant was pending.
You want a negotiation day also, or just,
Yeah, because that way, if they've got the proof, we can maybe resolve it that day.
yeah, we can do a agreed order if they've got the proof. That'd save them a couple of weeks.
Yes, Your Honor.
Okay. September 4th for negotiation day, September the 17th for next court day.
Thank you, Your Honor.
Yeah. Kyle Simmons. Commonwealth versus Kyle Simmons, 24 CR 0053. Are you Kyle Simmons?
Yes, sir.
Good morning. Were you born in 1990?
Yes, sir.
Last four digits, social security number 8515.
Yes,
You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation parole?
This is the PSI that I went over with, at the jail, where we talked about. So he's asking, have you gone over it?
Yeah.
Okay. Is there any reason this gentleman should not be sentenced today?
Judge, there's not a reason, in the PSI, I would just like to point out that, he was working as a farmhand and caretaker, when he was, arrested. But because he's been in jail, he's no longer employed, so I think he might have gotten confused when he was filling that out. But he had prior, farmhand and caretaker, employment.
You're saying his employment status is not exactly represented correctly.
It's my understanding his assumption was because he's in jail, he's unemployed, but he was previously employed, and I believe he.
Well,
would
you
be
were on
able
a
to-
pretrial diversion, which was voided on July 16th of this year. So we'll go ahead and sentence you to the 5 years. And then you need to talk about the possibility of shock probation or something when it comes around, if he can prove he's got some employment, okay? Is that correct? Is it okay?
Judge, I would like to argue for probation at this time.
Well, he just came off of a pretrial diversion, but go ahead and argue it.
Yes, Judge, he has had, his mother is his guardian. And so he already, financially, she's his guardian with that. He also, has been a caretaker. He's been a farmhand. He was only revoked on a DUI second, Judge. He did not pick up any additional felonies.
Well, let me tell you something. Concealed deadly weapons and DUIs are two of, it just drive me crazy. You know, when I let somebody out on probation and they get out and drive a vehicle and they hit a school bus or something, they'll say, well, what's the deal with this guy? He's out of control. So we'll take a look at the shock probation, but I'm not going to probate him. But he's out on a pretrial diversion, he gets out and drives under the influence. It's not going to happen. Okay?
Cooperate.
Thank you very much. Thank you very much.
Yes, sir.
Okay, out of custody, that, y'all don't have anybody else, do you? Do what?
Yeah, Brad.
He was actually put on the
Do what?
He is currently incarcerated at the Barron County Jail and they did a transport order. And so he was accidentally put on the out of custody portion of the docket, but he is in custody and we are ready to enter a plea.
Okay, Joshua Price.
Nope, go through it.
It's gonna be a felony plea.
Yes, sir.
Commonwealth versus Joshua Price. Twenty-six CR 0033, 26 CR 0034. Are you Joshua Price?
Yes, sir.
Good morning.
Good morning.
You born in 1995.
Yes, sir.
Last four digits, social security number 8492.
Yes, sir.
I've been informed that you wish to enter a plea today. Is that correct?
Yes,
Are
sir.
you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person that we just identified in 26 CR 0033 and 34? Is your judgment impaired today in any way?
No, sir.
Okay, have you had the opportunity to talk to your attorney? Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you, believe you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I accept the plea of guilty, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to use the evidence. Right to call witnesses in your favor and process issued to compel their attendance. You have a right to appeal this matter to a higher court if you lose, and right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea, you give up those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of essential provided law. I don't have to accept the recommendation prior to accepting any recommendation. I will await the pre-sentence investigation report done by probation pro. After reviewing that, if I decide that you should have a harsher sentence, you have a right to withdraw your plea and go to trial. You understand that? Ms. Gordon, Ms. Anderson, what do you,
Upon a plea of guilty to indictment number 26 CR 33 for the charge of possession of a controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 1 year. For indictment number 26 CR 34, burglary, third degree, the defendant shall receive a sentence of 5 years. The 1 year sentence in indictment number 26 CR 33 and the 5 year sentence in indictment number 26 CR 34 shall run consecutively for a total of 6 years to serve. Under indictment number 26 CR 34, the defendant shall have no contact with the victim's family, or the victim's real property. Commonwealth opposes probation. The defendant shall receive credit for time served, and the defendant agrees to have any and all evidence in the above style case forfeited and destroyed in a manner that's consistent with the laws of the Commonwealth and the holding agency.
is that your understanding what the plea was? Is that your
Yes, sir.
understanding? You have to say something.
Yes, sir.
It's a voice activated microphone, is the reason I'm asking that. Are you pleading guilty because you did commit the acts charged in the indictment as amended? Is that correct?
Yes, sir.
Okay. Doing so of your own free will, knowing your constitutional rights explained, is it still your desire to give up those rights and allow the court to fix your punishment within the range permitted by law? You understand that?
Yes, sir.
Okay, is that your signature?
Yes, sir.
You understand that after any of this plea, convictions of felonies in Kentucky could be enhanced in the persistent felony offender law. You understand that?
Yes, sir.
I accept the agreement, order pre-sentence investigation report and schedule sentencing for September the 17th.
Yes, Judge.
Thank you very much. Jennifer Brown. Commonwealth versus Jennifer Brown, 26 CR 0049. Are you Jennifer Brown?
Yes.
Good morning.
Good morning.
You were born in 1982.
Yes.
Last four digits, social security number 8405. You hear a pretrial conference. What's the Commonwealth have to say?
Judge, we're still in negotiations, so we were seeing another negotiation day, and then if we can't come to a resolution.
What's the charge you're negotiating?
It should be, I think, complicity to trafficking and then, wanton endangerment.
Okay, September the 4th would be negotiation day at 9 a.m. The next court date, September 17th, okay?
Judge, I got one quick question. She has been permitted through DCBS and family court to basically have contact with her children. The only thing that's holding her up is the lack of one word on this bond. Could she have no?
It's the one word, you know,
Could she-
one word do a lot of things, guilty,
Could,
not guilty,
could we
yes,
change
no.
could we change that just to no unlawful contact, Your Honor, with the children under supervision of DCBS?
Judge, we're not in agreement with that right now. That may be something we can work out at the next negotiation day, but not at this time.
Okay, thank you. Justin Bunch, Commonwealth versus Justin Bunch, 26 CR 0064. Are you Justin Bunch? Good morning. Born in 1982.
I was.
Last four digits, social security number 5069. You're here for the purpose of arraignment. You have represented by counsel. You have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with intimidating a participant in the legal process. You know what the charge is. I'm not saying whether you did it or not. Hand that to him. Counselor, you acknowledge the identity of your client received indictment, waive formal reading arraignment, enter plea of not guilty, reserving all pretrial motions.
I do, Your Honor.
I'm signing a reciprocal discovery order. Mr. Bunch requires the Commonwealth to provide you information to help you prepare for your defense. Y'all want a negotiation day on this?
We can, Your Honor. Yes, he's right now scheduled for trial, for September the 2nd. And the allegation in this case stems from the.
Okay, well,
the
we'll
case.
put a negotiation day on September the 4th.
Yes,
That'll be after the trial is scheduled, and then you got September 17th will be the next court date.
Yes, Judge.
Thank you, Your Honor.
Thank you. Jesse Couture. Commonwealth versus Jesse Couture. 26 CR 0038, 26 CR 0039. Are you Jesse Couture?
Yes, sir.
You were born in 1976.
Yes, sir.
Last four digits, social security number 2126.
Yes.
Here for the purpose of a pretrial conference. What do you have?
Judge, we are still negotiating on this. I think the Commonwealth Attorney's Office wants a little more time to see if they can get some records from
yes, Your Honor. We're still trying to
Indiana.
obtain some records from.
September the 4th, a negotiation day, September 17th, both of them at 9 a.m. are conditions of your bond, okay? Thank you. Gino Gregory. For review, it says, what is it?
Judge, what has happened is that the Court of Appeals returned a ruling that overturned the initial sentence in this case as an illegal
This
sentence,
one.
and so it needs to be
Yeah, where is Gino Gregory? Where is?
Judge, it is very possible that he was unaware that this was on the court docket today.
Okay, well, this is a situation where we need an agreement as to resentencing.
I think so.
So let's have him to come on.
Mr. Stockton wanted a negotiation day.
I was going,
Yes.
on September the 4th.
Okay.
Negotiation day on September the 4th and the next court date, the 17th.
Okay.
And I won't issue any warrant or anything for him right now.
Okay.
But I would like a summons issued for him to appear
Okay.
on the 4th and the 17th if we could, okay?
Thank you, Your Honor.
Yeah. Anthony Massengale.
Well, we're waiting on misdemeanor paperwork from the Commonwealth to be able to.
And
go over
Mr.
that with them.
Massengale, we'll call your case in just a minute, okay?
Thank you, Judge.
Joe Pruitt. Commonwealth versus Joe Pruitt, 26 CR 0057.
This is going to be a felony plea, Your Honor.
Okay. Are you Joe Pruitt?
Yes, sir.
Good morning.
More.
This is, were you born in 1968?
Yes, sir.
Last four digits of your social security number 2082.
Yes, sir.
We're here on I understand that you wish to enter a plea. Is that correct?
Yeah.
A motion's been tendered to that effect. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? Are you the same person that we just named in 26 CR 0057? That's you, right?
Yeah.
Is your judgment impaired today in any way? Are you all right?
Yes,
Know
sir.
what's going on? Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yeah.
Have you reviewed the evidence Commonwealth has against you, believe you're fully informed about your case? You understand that you do not have to enter a guilty plea, but you have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm gonna go over those rights. If at any time you don't understand it, we can step away and ask your attorney. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury. You have a right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor and have process issued to compel their attendance. You have a right to appeal this matter to higher court. If you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a plea of guilty today, you give up all those rights. You understand that?
Yes, sir.
And I may consider the Commonwealth's recommendation that I may apply a range of sentence provided below. I don't have to accept the recommendation. Prior to accepting your recommendation, I will wait for a pre-sentence investigation report to be done with probation and parole. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you'll have a right to withdraw your plea. You understand that? Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to possession of a controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 3 years, probated for 3 years, supervised. The defendant is currently enrolled in treatment at Spark and shall continue the treatment until completed. The defendant shall receive credit for time served. The defendant shall do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style case disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended? You do so of your own free will.
Yes, sir.
Okay. Knowing your constitutional rights, still your desire to proceed with your plea and allow the court to fix your punishment within the range permitted by law. You understand that after entering a guilty plea here, any future convictions could be enhanced under the persistent felony offender law. Is that your signature on there?
Yeah.
I'll accept the agreement or pre-sentence investigation report. Schedule sentencing for September 17th. You should remain free upon your bond. You need to talk to probation parole officer about it, okay?
Yes, Judge, thank you.
William Underwood. William Underwood.
We're gonna need a trial date for Donald Warren.
Does anyone know where Mr. William Underwood is?
Judge, I'm not aware of his whereabouts, but he is the one that has had medical issues periodically that have rose up.
Well, I'm sorry, I don't know where he is though. Issue a bench warrant without bond for Mr. Underwood. Donald Warren. Commonwealth versus Donald Warren, 26 CR 0058. Are you Donald Warren? Good morning. Were you born in 1978?
Yes.
Last four digits, social security number 9436.
Yes, sir.
We're here on a pretrial conference. What does the Commonwealth have to say?
We need to schedule a trial.
What's the charge here?
I believe it's trafficking, Your Honor. Let's see.
What's the problem with negotiation? It's just,
Judge, we received a split sentence to trafficking at this time. After looking at the case and advising Mr. Warren, he is wanting to invoke his right to trial.
okay, that's all you have to say.
Yes, Judge.
It's okay. I don't want to get into your defense or invade your
Yes, Judge.
attorney-client privilege. I just thought maybe it was a amount the offer was or that sort of thing.
And if we could look at a date, beginning of November, that way it allows enough time for me to file one more specific discovery motion.
I probably won't send it out to November. This is August.
Judge, I'm gone the last week of September and I have a couple trial dates already set in Barron for 2 days and 3 days in September.
I'm not gonna,
October.
I'm not gonna take it out to November. So we'll get your calendar out. We'll find a day here. I'm gonna accommodate you the best I can,
Yes, Judge.
okay? You already received all the discovery in this, correct?
No, Judge, I plan to file a specific discovery motion regarding non-one CAD logs.
Well, just tell us now what you want and I'll make the comma comply.
Yes, sir, Your Honor. Wade Webb's training certifications, 911 audio and CAD logs.
Let's go down,
And chain of
let's
custody.
go down through them slowly here. The first one was what?
Deputy Wade Webb's training certifications.
Okay, stop right there. You got that?
Yep.
Okay, what's the next one?
911 CAD and audio.
Okay, you got that?
Yep.
Okay, what's the other one?
Last one is chain of custody
On which evidence?
regarding the alleged meth that got sent to KSP.
Okay. We can do that. Okay. Uh, you gonna be on the whole month of September?
I'm gonna be gone that last week, Judge, but I do have trials set in September as well.
Okay, well. Look at the 16th of September.
Judge, I've got a 2-day trial. Starts on the 15th, ends on the 16th in Barron Circuit.
What about the 23rd?
I'm available. I could do that, Judge.
Okay, let's set this for a trial for September the 23rd.
Well, thank you.
Okay.
Thank you, Judge.
How long will it take you to provide that discovery?
We'll try to get it by next week.
Okay, that'll give you plenty of time to look at it. Okay.
Yes, Judge. Thank you.
Okay, the next thing is there anyone else here that was supposed to be in front of the court on a criminal matter? Next thing on the docket is,
We're waiting on paperwork.
oh yeah, I skipped over Anthony Massengale. Come on up.
Judge, this is the one we're waiting paperwork.
Yes.
That'll be an asking recall.
Yes, we're trying to get the
They're
plea
drafting up a
paperwork.
misdemeanor.
Okay.
Judge.
Okay. Okay, well, let's go off the record here. We don't have anything else scheduled till 10:30.
Please support the.
Yes.
Zachary Woods on for an arraignment.
Okay, can we get Little Sandy Correctional Complex on, Little Sandy? You turn that microphone on there at Little Sandy.
Yeah, we're on here, Honor.
Okay, thank you so much. Commonwealth of Kentucky versus Silas Tabor. Are you Silas Tabor?
Yes.
This 25 CR 0042. Mr. Tabor, were you born in 1976?
Yes.
And the last four digits social security number is 6042.
Yes.
Okay, what does the Commonwealth have to say in this case?
Your Honor, we're needing another negotiation day.
Okay, let's set a negotiation day for September the 4th and the next court date for September the 17th. Will y'all want this gentleman transported?
Yes, Judge.
If you'll submit a transportation order, we'll send it up to Little Sandy and we'll have him transported back down here.
I'll get that prepared.
For both. Both, yes. Okay, Mr. Tabor, your attorney will be in contact with you. We will transport you have you transported down here for the negotiation day on September the 4th and for your next court date on September the 17th. Is that all we need, Counselor?
That's all, Judge. Thank you.
Little Sandy, we appreciate your cooperation very much. Y'all are excused.
You are welcome, Your Honor.
Taylor County Detention Center.
I'm not on, Judge, and I was informed that they're in the middle of their regular motion day, so I don't know how available they are today.
Okay, well, we'll come back and check with them intermittently. Somebody can. Now, what is this?
Dare County. That's the one you asked me to add on. She's not on your schedule.
Okay, we need to do an arraignment here. An Adair County arraignment. And I'll need the public, to Cumberland County, I'd leave public advocacy to stand in because the regular public advocate is not available and we'll do the arraignment here.
Yes, Your Honor.
This is Commonwealth of Kentucky versus Eva Jo Nethery, Cumberland Circuit Court, case number 26 CR 0052. Are you Eva Jo Nethery?
Ava. Ava. Hey. Hey, Eva. He's talking to you.
Are you Eva Jo Nethery?
Yes, sir.
Okay, were you born in 1960?
Were you born in 1960? What year were you born? 1960? Yeah.
The last four digits of your social security number are 0743. Is that correct?
Is that the last four of your social? Ava, is that the last? Yes.
Okay. You're here for the purpose of arraignment. You have a right to remain silent. Your regular attorney cannot be present, but we have someone standing in today from the Office of Public Advocacy. You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with wanton endangerment, first degree, 3 counts, possession of controlled substance, 3rd degree, and driving under the influence, and possession of controlled substance not in the original container, and reckless driving. You understand what you've been charged with, is that right, Eva?
You understand what he said?
You understand that you've been charged with these crimes, correct? Eva, you
Yeah.
understand these charges that I just read against you, that you've been charged. You understand that?
You understand what he's saying? Yeah.
Okay, you acknowledge the identity client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Now, when do we have a negotiation date for Cumberland County?
Believe it is August.
Mm-hmm.
It was actually the 14th, when we had it. It's last week. I will get with Mr. Sheffield next week.
Okay, the Commonwealth Attorney is going to contact Mr. Sheffield. It appears to me that there might be some competency issues and other issues that need to be addressed. Dare County, thank you for allowing us to,
Set it for pretrial next week,
yeah, what is the date?
27.
27th of August will be the pretrial. And Commonwealth, we'll send a transportation order or do it by Zoom, depending on what your attorney wants to do. Okay, thank you very much.
Thank you, Your Honor.
Thank
We'll-
you.
Thank you. We'll forward it. Mr. Stockton, you want to just forward the indictment?
No, that's a docket sheet.
Oh, here, I thought I had, where was the
We don't
indictment?
have an indictment. Come on.
Oh, it's just a docket sheet. I read it off of here. Okay. Okay, no problem. Thank you.
So we don't blame them.
Okay, could someone, I guess, Taylor County will have to kind of wait and see.
Your Honor, I believe I'm on that case. I'm willing to waive her appearance if that will convenience the court.
Well, it probably could if it's a pretrial conference, but we got an arraignment though.
Yes, sir.
You know what I mean? Let's go off the record here for a second and let's see if we can call up there. Who's the jailer up there now, you know?
All these judges are on their criminal.
I know
Around, I'll get them to.
What are we gonna do then?
Contact information. I'll get back with you.
Let's go back on the record then. I guess we got Anthony Massengale, is that correct? What is the charge?
Salt second.
Yeah, let's trial that then. You are Anthony Massengale?
Yes, sir.
Born 1977. Last four digits, social security number 6135.
Yes, sir.
We're here on 26 CR 00044. Negotiations have fallen through evidently.
No.
That trial that we scheduled on the 23rd. That is it's a drug charge, right?
Yes.
Okay, so it'll probably take a while. Look at the 25th, September 25th.
Judge, I'm flying out of the country on that day. And I'll be gone that all next week.
What about September the 9th?
Week after, but
Technically, I'm available.
Okay, good. September. September 9th.
Judge, if there would be any last minute motions in limine or specific discovery. what would be-
I'll accommodate you.
All right. Yes, sir.
The problem we may have, Judge, is that Matthews went to the doctor out of state. And if we can't certify those medical records from any physician, I don't know that we can try it that quick.
Our victim.
in this case.
Okay, well, let's
That's
just
why
set,
everybody at Skyline from Monroe County.
okay, let's just set it for that date. And if we have a problem with that, we'll reset.
Yes, Judge.
Okay, see you then. Okay, let's go to Berrien County. James Farber. Armweather versus James Farber. Are you James Farber?
Yes.
Good morning. This is 25 CR 0059 Commonwealth Kentucky versus James Farber. Mr. Farber, were you born in 1994?
Yes, sir.
Last four digits, social security number 0603.
Yes, sir.
It was a Commonwealth having this case.
Yes, Your Honor, we're here on a revocation hearing. It's based upon him absconding.
And Judge, if I might, he was just picked up from Arkansas and delivered, I think, on Saturday or Sunday. I've not had a chance to meet with him to speak to him about what his side is of this, or if the court would be willing to give us one additional date. I don't think
We've got some body cam footage too that you may want
Okay.
to review of the,
Hey, you want to set it for you don't need to go, you want a negotiation day on this? Negotiation day on September 4th, next court date on September 17th.
Thank you, Judge.
we just got that, so we can.
Kayla Hunter.
You'll be here next week.
You got it down for a
Are you Kayla Hunter?
Yes, Your Honor.
You step back away from the camera a little bit so you see a little bit better. This is 26 CR 00066 for arraignment. Ms. Hunter, were you born in 1993?
Yes,
Last four digits of the social security number is 0332. Is that correct?
yes, Your Honor.
You have a right to remain silent. Office of Public Advocacy has been appointed to represent you. The grand jury of Monroe County has returned an indictment charging criminal abuse in the second degree, assault in the second degree, cruelty to animals in the second degree, and resisting arrest. You understand what those charges are?
Yeah, yes, Your Honor.
Counselor, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
I do, Your Honor.
Have a negotiation date set for September the 4th, and the next court date, September 17th. Your attorney will be over to see you to discuss these matters. You okay?
Yes, Judge.
Thank you. Commonwealth versus Jonathan Jameson. Are you Jonathan Jameson?
Yes, sir.
Good morning. This is 26 CR 00061. Mr. Jameson, were you born in 1992?
Yes, sir.
Last four digits, social security number 7403.
Yes, sir.
You have an attorney in this case?
Kevin Barron.
Office of Public Advocacy will continue. They're here. You have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with possession of drug paraphernalia and trafficking in controlled substance first degree. Counselor, do you acknowledge the identity of your client? Now the received indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
We have September 4th for negotiation day and September 17th for court date. Your attorney will be over to talk to you about this.
Thank you, sir.
Okay, thank you. Commonwealth versus Kenneth Joyner. Are you Kenneth Joyner?
Yes, Your Honor.
Good morning, Mr. Joyner. This is 26 CR 0015 for arraignment. Were you born in 1992?
Yes, Your Honor.
Last four digits, social security number 2559.
Yes, Your Honor.
The Office of Public Advocacy previously represents you, Public Defender's Office? Or do you have-
Yes, sir.
Yeah, okay, I'll continue that appointment. The grand jury of Monroe County's returned an indictment charging you with flagrant non-support violation of KRS 530.050. Counselor, you acknowledge the identity of your client, received indictment, waive formal reading and the plea not guilty, reserving all pretrial motions.
I do, Your Honor.
Okay, we'll schedule a negotiation on September 4th and the next court appearance on September 17th.
Yes, Judge.
Your attorney will be over to see you. Commonwealth versus Jamie Piercy. 20 CR 00021. Are you Jamie Pearson?
Yes, Your Honor.
Morning. We're here on your cases. Were you born in 1987?
Yes, sir.
Last four digits, your social security number 9146.
Yes, sir.
You're on a shock probation revocation. What does the Commonwealth have to say?
Your Honor, this was on last month, and you passed it. I think to see if he made any additional payments. Child support's only showing that he made a payment in November of last year and a payment of May of $306.50 each time. So he's not paid anything. He was the one we shopped out, and I can vividly remember him standing here, said, if you let me out, I'll pay every month and there won't be any problems. Well, we paid problems. Well, it's basically skipped supervision starting in May this year.
Judge, I've talked to him about it. I stressed to him that we needed to get a payment in here. I don't know what else I could say for him. Other than he can't pay while he's in there, so.
Okay. Okay, well, I'll just revoke the shock. And you can serve his time. Thank you. Commonwealth versus Danny Russell.
Gary said he had to take a Zoom call from Mark. He just passed that case and Jonathan Russell to the end of the document.
Danny and Dylan Russell.
Danny and John.
Okay, Danny, your attorney had to step out to take a Zoom meeting in next court. So we'll call your case back out and Jonathan will do the same thing. We'll call Dylan Russell up though. Commonwealth versus Dylan Russell. 26 CR 0065. Are you Dylan Russell?
Yes, sir.
Born in 1996.
Yes, sir.
Last four digits, social security 1233. You're represented by the Office of Public Advocacy. You have the right to remain silent. The grand jury of Monroe County has returned an indictment charging you with receiving stolen property, having a value of less than $10,000, criminal mischief in the first degree, operating a motor vehicle on revoked or suspended, being a persistent felony offender as far as the stolen property, and a persistent felony offender as far as criminal mischief first degree. Counselor, do you acknowledge the addenda your client received indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions?
I do, Your Honor.
The negotiation date for September the 4th, the next court date on September 17th. Mr. Russell, I'm signing a reciprocal discovery order right now that will require the Commonwealth to provide your attorney all the evidence that they have that is discoverable that you might use in preparation of defense, okay?
Yes, sir. Thank you.
Thank you. Amanda Sanchez, for the purpose of the arraignment. Commonwealth Kentucky versus Amanda Sanchez. Are you Amanda Sanchez?
I am.
Good morning. This is 26-0063. Ms. Sanchez, were you born in 1989?
Yes.
Last four digits, social security number 1943.
Yes.
Okay, you represented by the Office of Public Advocacy, is that correct? Or if
I've not spoken to anyone.
you what?
I've not spoken to anyone.
Okay, did this go through district court?
It did.
Did they represent you in district court, public advocates?
They did. They
Okay,
did.
well,
I was just indicted.
okay, I will appoint them to represent you, but you can remain silent now. I'll just read the indictment and charges, and then they'll come over and talk to you about it. Okay? The grand jury of Monroe County has returned an indictment charging you with speeding, fleeing and evading, wanton endangerment, 4 counts, reckless driving, improper passing, failure to use seat belts, operating under the influence, operating on revoked, resisting arrest, disorderly conduct, persistent felony offender on fleeing or evading, persistent felony on wanton endangerment first degree, persistent felony on wanton endangerment first degree, persistent felony on wanton endangerment first degree, and persistent felony on wanton endangerment first degree. Counselor, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
I do, Your Honor.
Ms. Sanchez, I'm signing an order here which will require the Commonwealth to provide you and your attorney with information they have to help you prepare for your defense. I'm setting up a negotiation date for you on September the 4th, and the next court date is September 17th. Both of them are conditions of your bond. Your attorney will be over to talk to you. When are you going over there?
As soon as I can, Judge.
Well, I'm gonna give her a time frame.
Thursday or Friday.
Okay, he'll be over there this week to talk to you, okay?
All right, thanks.
Thank you very much. Commonwealth versus Jonathan Scott. Are you Jonathan Scott?
Yes, sir.
Good morning. We're here today on 26 CR 0035. Mr. Scott, were you born in 1974?
Yes, sir.
Last four digits, social security number 0956.
Yes, sir.
You're here on a pretrial conference. What do we have?
Your Honor, I believe that we've reached an agreement in this case, but we just need a
We-
negotiation.
We need another
date.
negotiation day to do the paperwork, Judge.
September the 4th for negotiation. September the 17th, the next court date.
All right, thank you.
Thank you. Commonwealth versus Robert Simpson.
That's that.
Are you Robert Simpson?
Yes, sir.
Good morning. We're here on 24 CR 0079. Mr. Simpson, were you born in 1991?
Yes, sir.
Last four digits, social security number 5031.
Yes, sir.
From probation revocation. What does the Commonwealth have to say?
We're needing another negotiation day on this one, Your Honor.
September 4th for negotiation, next court appearance, September 17th. Your attorney will be able to talk to you, Mr. Simpson.
All right.
Damian Tackett. Damian Tackett. Are you Damian Tackett?
Yes, sir.
Good morning. This is
Morning.
here on 25 CR 00019. Mr. Tackett, you born in 1984.
Yes, sir.
Last four digits, social security number 4520.
Yes, sir.
We're here on probation revocation. What does the Commonwealth have to say?
It's my understanding that the defense is needing some time to speak to him, but they haven't.
That is correct, Judge.
September the 4th,
He didn't know we had him.
negotiation day, and September the 17th.
Yes, sir. Thank
Give
you.
you the hard. I'll give you
Your
the-
attorney will be able to talk
I'll
to
give
you.
you,
Dwight Walker. Commonwealth versus Dwight Walker, 26 CR 0054. Are you Dwight Walker?
Yes, sir.
Good morning. Were you born in 1975?
Yes, sir.
Last four digits of social security number 3012.
Yes, sir.
Okay, we're here on a pretrial conference.
We're needing to set a trial date, Your Honor, in this case.
What kind of case is this?
It's a trafficking,
Okay,
Dwight Walker. The second, this is the second thing.
what about September the 16th?
Say September 16th.
It's fine with Mr. Lanham's calendar, Judge. That's fine with Commonwealth.
Okay,
That's fine.
I have 3 Wednesdays in a row here. Oh, yeah.
We got to go to the last person.
Okay,
Do we need to put it on to make sure that?
we'll go ahead and do it. If they can't be here, we'll
Okay,
get y'all on the phone, schedule a different day.
okay. So no need for another pretrial then, Judge.
No,
Okay, thank you.
yeah, that was Mr. Walker, is that correct?
So if you don't have anything going on in month.
Your attorney will be overseeing Mr. Walker is scheduled a trial on August 18th. Since you're incarcerated, you what?
September 6th.
Excuse me, September 16th, that's it.
Can't get a bond reduction, Your Honor?
Your attorney will be over to talk to you.
All right, thank you.
Thank you. Zachary Wood. Commonwealth versus Zachary Wood. 26 CR 0055. You're here for the purpose of arraignment. Mr. Wood, were you born in 1998?
Yes,
Last four digits, social security number 6611.
yes,
Your attorney is present. You have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with criminal trespass in the second degree, arson in the second degree, and terroristic threatening in the third degree. You understand what those charges are?
yes,
I'm gonna ask you what you did. Charge. Counselor, you acknowledge the identity of your client, received the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Do a negotiation day on September 4th. The next pretrial is on September 17th. You'll be responsible for doing the transportation orders.
Yes.
Okay.
Sorry. Yeah, briefly be heard on.
Do what?
Do you have him at 10 so for the record?
Yeah, give us your contact information.
My name is Matt Baker. I'm from Bowling Green. I represent the defendant.
Okay.
Commissioner Baker, we'll need your emails so we can.
Absolutely. Briefly be heard on the issue of bond, please.
If you'd like to have a bond hearing, you can.
Judge, I represented Mr. Woods in the Monroe District Court, and despite my best efforts at the preliminary hearing, we were not able to get the case resolved. After the matter was bound to the grand jury, Your Honor signed a RCR 522 order releasing him from custody on March 31st of this year. That was 25F097. Since that time, he has lived with his mother in Gallatin, Tennessee. He's gainfully employed full-time at Precision Castings. And despite the fact that he's been incarcerated for several days or a couple of weeks, he has a job waiting for him. They'll have him back today if the court would see fit to release him.
Well, I don't, here's my problem. I have no reason to doubt anything you say, but Commonwealth has no reason. You need to work with them and provide them some information. I don't know anything about the case.
I corresponded with Mr. Stockton and he told me to take the matter up with you. So,
Well, what do you say, Mr. Stockton?
Hey, Mr. Baker can provide me proof of employment and address where we staying.
Okay, what are you gonna,
I want him to stay in Tennessee during this, other than these court days.
well, I'll need him to sign a waiver of extradition too.
yes, sir.
So we'll provide a waiver of extradition. You can get him to sign that. And then what kind of bond do you think? I mean, these are serious charges. I don't know. Tell me something about the case.
Well, it's alleged that he burnt this structure. I don't know if there's a female that had been in it or whatever. That's the allegations. I don't know why the case drug on so long before we got it. Recently released.
Well,
But evidently, we got him arrested and everything after we indicted him, so.
Court would consider a surety bond.
I don't know. I'm gonna have to know more about this case.
You probably need to make a security bond since it's on the outside.
Well, a surety bond would have to be made by somebody in state.
Yes, sir.
I just think we probably need to do some sort of bond. You know about this case? I mean,
Just when it was, before it was presented to the grand jury, I remember looking up. So if we have a bond here, I'd probably need to call a witness.
Yes, exactly.
I don't mean to monopolize your docket this morning. I can take up the matter with
oh,
Mr.
that's okay.
Stockton.
We got a lighter docket than usual.
Seen on camera.
Yeah, we only placed him in NCIC in August, so we didn't have any trouble after.
Yeah, now the words NCIC come up to me. That's the first time I'd heard those
I
words.
guess because it was out of state. There was an allegation, Your Honor, that there was a verbal domestic disturbance between Mr. Woods and Mary Bennett, who'd been arguing and had recently ended the relationship. He was on ring camera making him gestures of pointing a gun and sending text messages he was going to kill her. And then was also on ring camera igniting a tiny home that she lived in.
Okay, no, we're not gonna have any, we're gonna have a hearing on this. So,
It's also been in this meeting.
yeah, we'll schedule a hearing on September 17th.
We have the ring camera.
And we got an NCIC out-of-state person with
He was
those
in NCIC for 2 days.
2 days. Yeah, okay. Okay, thank you very much.
And you'd like us back when, Judge?
17th, September 17th.
Pleasure to be in your courtroom,
Yeah,
Judge.
you have a
Great
safe
day.
trip. Thank you for being here. Is there anybody else? I guess we got those two we passed over from Mr. Garrett, right?
Yes, sir.
Danny Russell and Jonathan Russell.
Yes, Judge.
Represent both of them. Do you have a waiver on these two fellows, do you?
They're not co-defendants, Judge.
They aren't? Okay, well, let's call Danny Russell first. They just share the last name. Are you Danny Russell?
Yes, sir.
And this is the one for the suppression hearing?
Yes.
Let's call Jonathan Russell first then. Jonathan Russell, and then we have Danny Russell. You're Jonathan Russell?
Yes, sir.
Okay, you're here on 26 CR 0053, an arraignment, and then 23 CR 00012. Are you born in 1978, sir?
Yes, sir.
Last four digits, social security number 7142.
Yes, sir.
Okay, I'm gonna do the arraignment first. The grand jury of Monroe County has returned an indictment charging you with strangulation in the second degree, assault in the second degree, unlawful imprisonment in the first degree, being a persistent felony offender as far as assault, strangulation, and unlawful imprisonment. You understand what the charges are, correct?
Yes, Your Honor.
Okay. You acknowledge the event of your client,
I do, Your Honor.
receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
I do, Your Honor.
Set this for negotiation day on September the 4th, and next court appearance on September 17th.
Judge, would the court be willing to consider a $10,000 property bond?
I'm not going to consider anything without knowing more about this. These are serious charges. We can you can schedule a hearing,
Okay.
okay?
It's a probation revocation and a new place.
It's probation revocation also besides that. Okay, thank you. Your attorney will be over to talk to you. Now,
Thank you.
the suppression hearing, Mr. Johnny Russell,
Yeah, you're up.
excuse me, I crossed out the wrong one, Danny Russell. Okay, you filed a motion to suppress on Mr. Russell's case.
There was a motion filed before I entered the case, Judge, but I'm going to be doing that hearing.
Okay. You want
You can do that from the table, or what do you want?
to, let's do it there. You want to, what are you challenging for as a search?
Judge, there was a DCBS request to visit the property there at Danny Russell's. DCBS then asked the Monroe County Sheriff's Department to accompany them. The initial approach to the residence was at the house, under case law. Obviously, an officer, even under Clore versus the Commonwealth, officers can be where they're lawfully supposed to be. They went to the front door, did not receive an answer. The officers then went to the back door, didn't receive an answer. One officer then walked approximately 30, 40 feet, or maybe a little bit further, to a garage located on the property near the back of the property. Entered that garage, and then based on that, got a search warrant, despite the fact that DCBS was called to the residence. Officers accompanied them, and the initial, or I think the only lawful activity conducted by the officer should have been just to approach the front door to see if he was home or if anyone was home. I think to go to behind the home to the back of the curtilage and check that back door, and then to venture off from the original, I guess, mission, which was to accompany DCBS and then go to the building located on the property, was in violation of his Fourth Amendment rights. So there's a case out of Hart County, Quintana versus the Commonwealth, under Judge C, that basically says that officers can visit a property where there is a public access point, but to go in areas such as a curtilage, in areas that they would not have originally had public access to, is a violation of the Fourth Amendment. That's essentially what this case is. They have some officers, we're going to put on some proof.
You had a warrantless search and a search warrant, was it correct?
It is a warrantless search, partially done,
Was there a warrant subsequently obtained for that building?
at a different time, on different basis.
You're not challenging that.
Not at this time. I'm just challenging it.
I just don't know what we're hearing about.
Yes.
There was also a consent search involved.
Okay. Okay, you want to call your, in this case here, consent? Okay. You want to call your first witness?
Called Gary Smith. Now, I also have other witnesses. I don't know if you want to-
Yeah, we'll apply the rule.
Yeah.
Apply the proof. Anybody that's a witness in this case needs to step outside the courtroom. Y'all want to make room for Mr. Garrett over at the defense table, Mr. Garrett, so you can take notes and that sort of thing. You raise your right hand, you swear the testimony about to give is the truth, whole truth, and nothing but the truth. Take a seat there, leaning forward to the microphone. In your outside voice, tell us your name.
My name's Garrett Smith.
Proceed.
By whom are you employed, Mr. Smith?
I'm employed for the Cabinet for Health and Family Services,
And how long have you been employed in that position?
3 years.
Prior to that, what kind of education did you have that would qualify you to be working with child services and abuse, dependency and neglect and so forth?
Yes, I obtained my bachelor's degree at Western Kentucky University in 2016. Started with the Cabinet 2023, completed all my formal training with the Cabinet, my first 6 months, all the mandatory classes, and continue to have all of my requirements and further training met through the Cabinet.
Now, are you aware of the case that we're here on today
I am.
concerning Mr. Russell?
Yes.
Did you get this out now? How did you first, were you involved in the case and did you go to the premises there that day on December 26, 2025?
That's right, yes.
How did you get involved in the case?
I received, it was assigned to me by my supervisor. I was the worker on call that day. We received a report through our online reporting system, and the allegations came through our centralized intake that there was allegations at that residence. It was, I believe, marked as a 24-hour, or it might have been a 4-hour. I would have to look at my notes, but it was of concern that day that we go to that residence.
What were the natures of the allegations that were made that brought your office and you involved in this case?
Right. The allegations came in for suspected drug use in the home, suspected domestic violence, that both parents had been in the home at one point, and there was allegations of domestic violence around the children, substance use around the children, as well as possible drugs on the property.
Was there a report generated concerning the beginning of this case?
There was.
Who did that? Did you do that, or was this done?
So that comes through our the online reporting system. Centralized intake sends an intake, and it's assigned an intake ID, sends it to our office. It's sent to my supervisor, and then at that time, she assigned it to me.
Right. May I approach the witness, Your Honor? What it is.
This is our DVP 115. This is the document that is sent to our office whenever there are allegations. It's comes from a centralized intake.
And this is the background of what got you involved.
That was yes, the information that I received when I first responded to the call.
And I will move to at least a copy of this be filed in the record, Your Honor.
Please, that's the whole 52 pages.
My motion is to file this, Your Honor.
What is this?
It's the Commonwealth of Kentucky Department of Community Services.
But how many pages?
6 pages, 5 pages.
Judge, I would ask that the entire document be placed in.
What is the entire document? What's the difference between what you have in the entire
I
document?
don't have any idea, Your Honor.
You want to elucidate a little bit?
Judge, there's 52 pages worth of a twist history based on DCBS coming to the residence. His testimony is a little different than what the initial call was, but that document will help to demonstrate all the reasons why he appeared at the residence.
The purpose of this document here is to show why Mr. Smith was there and why he was accompanied by 2 deputy sheriffs.
Okay, well, I'm gonna admit, you submit what you have there, and then if you want to use any other document, you have to cross-examine a witness, you'll be able to. You want to submit it for introduction now, Mr. Hunley, or you want to testify?
Well, I got further questions on
It'd be
it.
great. Proceed.
Was this document directed to you for an investigation?
It was.
And did it involve children?
Yes.
What were their ages and names, if you recall? We'll leave the names up. Let's go with their ages and sex.
At that time, there was an 11-year-old male, a 12-year-old male, and I would have to check my records for the exact age, if that's all right.
And anyone else?
4-year-old female.
Now, as a part of the document that created your position there, is there a portion of it that relates to potential unsafe conditions or the safety that you might face in making an investigation?
It's listed towards the end of the allegations. I believe it's safety factors or risk factors, things to consider when you're going to.
What were the circumstances that were given to you about the potential risk?
Potential safety threats were current or past substance use abuse, current threats of harm or history of violence, owns weapons, firearms, past or present.
Now, is it normal in cases like this for you to go to the premises and actually try to find the children and investigate personally their situation?
Yes.
Is it normal for you to take law enforcement officers with you?
In these sort of circumstances, yes.
And who made arrangements for the officers to go with you?
I did. I believe I called the sheriff's office.
And Officer Richard Shirley and Officer Austin Cooks went with you that day?
Correct.
And where did you go?
To the listed address on Acresville Road.
Have you obtained a copy of aerial photographic copy of the premises that we're discussing here and where the
Supposed to be like that. And you want to do the same.
Hey, Judge. Only got. So at least I notice it. Yeah. What's going on with it? I'll take the cameras out. Small gap, all back to. Yeah, reading, I'm not cool. that they see there at the residence?
Yes, they found a backpack that had some marijuana in it. I'm not exactly sure the exact location. I believe it might have been in a bedroom. They also found a container, which at that point they noted to me that they suspected it to be methamphetamine residue. That container was found by Deputy Shirley inside of a console within the couch in the living room.
Did Mr. Russell make any comments about the ownership of either the marijuana bag or the methamphetamine, possible methamphetamine?
To me, he denied ownership of anything that was found.
Did he not say that the marijuana was his, but he didn't have anything to do with the man? If you heard.
I didn't hear that portion of it. Whenever I spoke to him, he denied everything that was found.
Now, in the normal procedure, when you are sent out for a abandonment or a physical abuse threat on children, even a female as young as 4, would you have made a thorough search of that entire property looking for those children?
Yes.
Is that what the officers had in their mind when they arrived there?
Sustained.
When the officers left the back of the house and were leaving, and you were with them, did they deviate from the straight path from where they were to their car until they found the marijuana in the car on the side?
I don't believe
I mean,
so.
did they wander off anywhere and look at this building, look at that building, look at this car, look at that car? Or were they just making a approach going straight back to their car?
Straight back to the car.
Excuse me just for a moment, John.
What day is it?
Today?
Yeah, I know I would ask you what time it is, but this seemed like it's already lasted more than a day, so Let's move it along a little bit.
Were you able to, did you see bagged marijuana, bags of material taken from the garage?
Objection is to relevance, Judge, where this is, if I might explain.
I'm gonna go ahead and let it proceed.
And he may not have seen this load. I won't show him the picture. Well, Mr. Smith, if you would look at these three photographs, and did you recognize anything that you see on the photo?
Yes.
And tell the court what you recognize.
The containers, look to be filled with the marijuana residue, that was pulled out of the garage that day, as well as the bags of marijuana.
Okay, let's move it along.
Well, these is,
No objection ordered.
that's all for this witness, but I said.
You don't have any questions, do you?
Oh, I got you, Judge. But I'll be quick.
Go ahead.
So, Mr. Smith, so you stated a while ago that you got an intake, it's assigned an ID number. Do you have that report before you?
I do.
Okay. So the initial complaint was that the reporting source stated the mom, Shannon, was recently incarcerated in 2024, the year before, due to substance abuse, and she wasn't supposed to have unsupervised contact with the children. Would that be accurate?
To my knowledge, are you asking me if it was accurate that I would know that before, or?
So I'm asking you.
Read what the report was.
Oh, yes, that's what it says, yes.
Okay. And the reporting source was concerned about contact with the children, correct? Shannon McGuire's contact with them, right?
Correct.
Now, the reporting source stated several things that had occurred in the past. Would that be correct? Not things that were currently happening. Would that be fair?
It says in the reporting source states both parents are smoking. I would consider that to be in the present.
Okay. Now distinguish for us what 4-hour and the 24-hour response time is, because you brought that up a while ago. What's
Sure.
the importance of the time for responsive?
Give me just a second.
Hold on just a second.
You do it. I want the business that. Sorry, back. Okay, thank you. Go ahead.
So what is the difference in responding in 24 hours, 4 hours, and what is that whole paradigm? What is that for?
Sure. So to determine whether that response time is a 424 or a 48-hour, and we have something new called AR, which is 5 days. We assess, meaning we do if we get it directly, or the centralized intake assesses certain risk factors. So age of children is also a factor that will go in to determine whether if this report needs to be initiated sooner, as 4 hours is our soonest response time.
Okay. So this summary of what the reporting source gave to initial intake
Sure.
did not merit a 4-hour response. Would that be fair?
Correct.
Because the intake assigned this a 24-hour response time, correct?
Correct.
Now, despite the questions that was asked of you a while ago, there was no assertion or claim by the reporting source that there was active domestic violence. Would that be correct?
The reporting source says,
I'm sorry, Judge,
Well, no,
Ma'am.
let him ask cross-examination.
in the report, it states that mom stays over at dad's and they have physical fights.
I'm sorry, what was that? Had physical fights?
Have, HAVE.
Okay. Now, in the context of the entirety of that paragraph, it says you did not read that to be that they are currently fighting. But wasn't that basically a summary of the activities as to why DCBS had been there before?
I'm sorry, can you repeat the question?
So it says, reporting source states mom will stay over at dad's home and they have physical fights with the children in the home. Is that happening now as you took it, or was it happening as a history of what you were being given based on this report?
Or both.
Or both? Thank you.
I would consider both.
Okay, so, but this was given a 24-hour response time, isn't that right?
I believe because it was on call, the response time wasn't, whenever we get there's two forms that come in. The initial one is that 5-page that I get. If it's on call, or after hours, this was on the day after Christmas, then that 50-page will come after. I didn't receive that until after I'd made contact with the family. So I don't believe at that point I had a time frame. I just responded as I would on call.
Did you ask whether or not there was active domestic violence?
Here's the thing about it. His decision on the urgency to attend is not relevant to me, so just move on. You can make an argument. I understand the point you're trying to make. You can argue that point.
Now, when you arrived at the property, you all pulled up the driveway, correct?
Correct.
And do you remember which officer, as was claimed a while ago, saw some marijuana in the windshield? Do you remember which officer that was?
I don't recall.
Did you see it?
I did.
Okay. So you all walked up the driveway. Was that marijuana seen going up or returning from?
Returning.
Okay. So when you all went up the driveway, where did you all go? To the front door?
The front door.
Okay. And which person then went to the back door? Or persons? When there was no response at the front door?
I believe we all did.
Okay. There was no response to the back door?
Correct.
And did you leave at that point?
Yes.
Okay. And at what point did the officer deviate from leaving and go to the building on the property?
I didn't see that. I was already at my car.
Okay. And so the officer waited behind and went, or?
We left the back door. On the way to the vehicles where we were parked, there was a truck that had marijuana residue. I didn't see it at first. The officer pointed it out. I looked at it. I went back to my car to call my supervisor.
Okay. And then you later said that you went to the building where this marijuana was allegedly found?
Correct.
And that was a garage?
Correct.
It was open?
It was.
Okay. And you said there was some discussion about whether or not a search warrant was needed on the phone with
Something that I overheard, yes.
and despite not having a search warrant at that time, the officers went on into the building and started searching?
Correct.
Okay. And did you describe earlier that all the marijuana was in the rafters of this building?
I don't believe all of it was, but most of it, what I saw was them taking it out of the rafters.
Okay.
I think there was just things on the ground, but most of it was in the rafters.
Okay. Where were the bags located, do you know?
In the rafters.
In the rafters, okay. Was there anything that you remember that was on the ground?
I think there was some trimmings and there was some loose things on the floor, like stems, leaves, things like that.
Now, you said when you approached the threshold of the building, you smelled the slight odor of marijuana.
Correct.
Within 5 feet of that, could you smell that slight odor of marijuana?
I don't recall.
Okay. Would you recall that you didn't smell it until you got up to the building? Would that be fair?
Correct.
Okay, so you didn't smell it on your way from where the back door would have been on up to the building?
That's correct.
Okay. And I know this is going to be a stupid question, but I just need it in the record. So you could not have seen any of the marijuana from the roadway, from the public access road, could you? In that building?
No.
You could not have smelled marijuana in that building from the public access highway, correct?
No.
Okay. How many feet do you think that building was away from the home?
Mm, 20 to 30, maybe longer. I'm not sure.
Did you see any type of items between the house and the building? Like clothes or storage things in the yard or?
There was a lot in the, I mean, there was a lot of things on the property,
Okay.
different. Um, like vehicle parts, things like
Okay.
that. I wasn't
In the backyard?
on the whole property.
What about in the front yard?
There was things there too, yeah.
Okay, okay. Um. How long after, how long were you there at the property?
Altogether, probably an hour.
Okay. And a couple other questions. As you approached the building, could you hear anybody inside the building?
No,
Was it your belief that no one was home on the property at that time?
Did he have any knowledge of anybody being there?
Yep. Did you have any knowledge or could you observe anybody or anything which would indicate that someone was home at that time?
I didn't observe anything that indicated someone was home.
Okay. And you don't know which officer it was that left from the back door and then went to the building, correct?
I can't recall.
Nothing further.
You don't even redirect, do you, Mr. Chandler? Do you?
No, Your Honor.
Okay, may this witness be excused?
Thank you, Your Honor.
May be excused, Mr. Chandler?
Yes.
May be excused, thank you.
Thank you.
Call your next witness.
Oh, Richard Shirley.
You raise your right hand, please. You swear that testimony about to give us the truth, whole truth, nothing but the truth.
Yes, sir.
Have a seat there and lean forward to the microphone. And tell us your name with whom you're employed.
Officer, by whom are you employed?
Monroe County Sheriff's Department.
And how long are you a certified law enforcement officer in the Commonwealth of Kentucky?
I am.
How long have you been in law enforcement?
Since 1998.
Do you recall the day in December 20, right after Christmas last year?
I do.
Were you called to assist Mr. Smith and the Department of Community Services to assist him in going to a place seeking the welfare of some children?
Yes.
How did you become aware of what was needed? Who called you?
I honestly don't remember exactly how I got the call.
Are these calls normal that you go and assist the department when they ask you to?
Yes.
Was anybody else with you?
Yes.
Who was that?
Deputy Cook.
Is he another sheriff's department deputy?
He is.
And where were you asked to go?
We went to the home of Danny Russell.
Were you familiar with where Mr. Russell lived?
Yes.
And where was that? Where is that?
I forget the actual address. It's on Acresville Road.
How would you describe that area of Monroe County?
Not understanding.
Is it heavily occupied or is it
No, it's pretty rural.
had you ever been there before?
I had.
So what did you and Officer Cook and Mr. Smith do?
You just want me to start when we.
Yes, when you got there.
We pulled in the driveway. We all got out of our vehicles. walked to the front door of the house, knocked on the door.
What'd you do with your vehicle? Did you drive them all the way up to the house?
No, no, our vehicles were positioned. The driveway kind of comes straight in, but then there's an area where you can tell people have driven up toward the front door of the house. There's like a Y area, I guess you'd
Alright.
call it, right there, and we positioned our vehicles right there.
And what did you do? You walk up there?
Yes, we walked
All
up the
three
front
of you?
door.
All
Yes.
three of you?
Yes,
And did you knock on the door?
we did.
Have you get any response?
We did not.
How long were you there knocking on the front door? Just an idea.
Approximately, I guess, 3-4 minutes.
All right. And getting no response at the front door, what did you and the officers do?
We went around to the back door.
Could we put the Elmo up again or not? I guess not.
I'm sure we can. Help him put the elbow up.
For some other done you. Plus they had took everybody else on there. That's this one. But. Yeah. Yeah. Well, there were several men, right? There were several men. One funny thing, DCBS worker experience there, told me straight out of the mouth that they had no light on in my garage. I don't know what it, I don't know, next on that or what the can, I don't know.
Well, recognize that to be marijuana. What did you do?
After we got off, or after he got off the phone with the county attorney, then we proceeded to enter the garage. And of course, the first thing we did was took down that tote of stems and, we began to look around, finding other, finding marijuana in various stages of, like some of it, we found a few loose buds and, maybe in a bucket over here, we found a bag that had done been processed. You know, buds and things like that. There was a lot of shake on the floor throughout the garage.
Did you all remove it?
We did.
Did you all rebag it or just use the bags that were there?
We just used the bags that were there.
And you said that you'd seen some that had already been processed. What did you mean?
It was, the buds had already been taken from the stem. Didn't have any shake. It didn't have any nastiness in it. It was in Ziploc bags.
Let me show you a photograph and ask you to examine that and tell us if you recognize it.
I do.
What was that?
This is what we took out of the garage that day. The gray tote right here, is the original tote of stems that we saw.
All right.
This, I think, is, of course, you can't really see, but best as I remember, there's a lot of shake down in the bottom of this.
What about the others? It looked like garbage bags.
Right here,
There and below that as well.
that is, packaged. It's more like this, but they're in bags. There was a couple of those that we found in there.
Individual bag?
Well, inside these big bags, there are individual bags.
That's what I meant.
Yes.
It'll just be filed, yeah.
Objection.
At some point, did Mr. Russell arrive?
He did.
And what did he have to say about it?
Well, I'm really not 100% sure because I stayed more with the garage and Deputy Cook made contact with Mr. Russell.
All right. Did you all go to the house? In the
We
house?
did.
And did you make a search there?
We did.
What was the basis, the legal basis for you searching in the interior of the house?
Before we went into the house, I had approached Deputy Cook and Mr. Russell. And I did hear Mr. Russell say, yeah, come on in and look around if you want to.
He consented.
Yes, sir.
And what did you all find?
And I remember in the couch, the armrest, they like opened up and there was a storage compartment there, you know, for, I guess, whatever. Inside one of those storage compartments and the armrest of the couch, there was a tube that had been taped. Had a white substance inside of it, white powdery substance. We believed it to be a controlled substance.
Later, did you send that substance for forensic examination later?
My understanding, yes, sir.
Was your suspicion confirmed?
Pardon?
Was your suspicion confirmed?
I honestly don't know. I didn't see the report.
Okay. So at some point, did you and Officer Cook bring Mr. Russell to Tompkinsville for processing?
Yes, he was, Deputy Cook arrested, Mr. Russell and transported him back to the sheriff's office.
Were you there at that point?
I was there when he made the arrest, put him in the car, but we drove separately, so.
At any point, did Mr. Russell acknowledge or disavow ownership of either the marijuana or the suspected white powder?
I don't recall. Well, also, let me back up. Also, yes, what else is in the house? I know that in a duffel bag somewhere, Deputy Cook found a couple more of those Ziploc bags with processed marijuana in it. But I'm not sure where that was found. I was looking in a different part of the house at that time.
Did you hear Mr. Russell take ownership of any of that, or did he deny it?
I don't recall either way.
All right. Fair enough.
I'll let Deputy Cook do most of the interaction.
We'll get to him in just a minute.
Okay.
Now, the next day, after having acquired more information, was a search warrant for his property acquired?
It was.
And what portion of the property did you search in conformance with that search warrant?
We searched pretty much the entire property.
What all was located on that property?
There were a lot of, well, there was the house, the garage, there was a school bus, some pickup trucks sitting closer to the house, and then there were a lot of abandoned vehicles on the property.
Scattered?
Yes.
And did the search warrant authorize you to search the vehicles?
Yes,
And did you search the vehicle?
we did.
Tell the court what was found in those abandoned vehicles or old vehicles.
Well, first, when we got there, read the search warrant, Mr. Russell, he said, well, I'm gonna show you what you missed yesterday. So he comes out, opens the door, one of the pickup trucks that was second closer to the house, and he got a couple of duffel bags out. Inside the duffel bags were several Ziploc bags with processed marijuana. Mr. Russell then shut the door of the pickup truck. I walked over, opened the door back on the pickup truck, was looking in the truck just to make sure we had found everything in there. When the truck had a bench seat in it. When I leaned the seat forward, or the back of the seat forward, there was a rifle behind the seat with a magazine in it.
What kind of rifle?
It was an AR rifle, Bushmaster, I think.
Was that found in the same truck?
As the marijuana? Yes, sir.
that Mr. Russell pointed out is, this is what you missed yesterday.
Correct. Inside the passenger side door pocket of that same vehicle were, I forget exactly how many, but it was more than a couple, magazines for that same rifle. They were all loaded.
Y'all sees that?
We did.
Yeah, let me have the picture where the marijuana. No, big. It's the first one we put in. I'll show you what's all previously been filed as Commonwealth exhibit. Ask you to examine both of them and tell the court exactly what is there and if it makes any difference, whether it's on the upper tier or bottom tier.
Okay. Well, on top of the table is,
Is that a photograph of what?
oh, this is a photograph of what we found.
Is that a photograph of what you found in the 2 days?
I don't think this is the total amount, no.
Oh, that's marijuana that you found at the premises of Danny Russell.
Yes, that it is, yes.
Did you all weigh the amount, the actual weight of the marijuana that you found at Mr. Russell?
We did. I forget exactly what the number was. I know it was 50-something pounds one day and 60-something pounds the next day.
Was it more the first day or the second day?
I honestly don't remember. I think the majority was the second day, but I might be mistaken on that. I do know this picture here. This is what Mr. Russell said that we missed the first day and got out of the truck the second
Where
day.
the rifle was?
Yes. But again, the reason I know this is a picture from the first day is because, again, here's the tote of stems that was our first visual.
Or did you all rebag and put it all into those big bags, or did he actually have that big of bags of marijuana in his garage?
No, a lot of this shake, we did have to bag because it was just kind of loose in first one little container or another. But we got these bags were bags that were
Already done.
Yeah, they were already there.
All right. Now, would you please answer Mr. Gary?
Okay.
Get my back to the clerk.
You want these back? Okay. Thank you. What's your pen?
Chad Welch.
Yeah.
Deputy Shirley, I just have a couple of questions. So how many feet was this garage from the driveway?
From the driveway?
Yes, sir.
The driveway actually went into the garage.
Okay. From the walkway or the path that you all walked up to the back door or the front door, how far was that garage from that path? 20 feet?
There's every bit 20 feet.
Okay. Now, the path that you all took from your cruisers where you parked before the Y to the front door, how long was that path from your cruisers to the front door?
I'd say it was probably 50, 60 feet.
Okay. And then how far did you have to walk from the front door around the house to the back door?
Probably another 50 feet-ish.
Okay. And then
That's
when you
just
left,
assuming that the house is probably 20 feet wide. At that end. I don't know.
when you left from the back door, did you go straight to the vehicles?
We were headed straight toward the vehicles.
And at what point did you then go towards the garage?
Well, like I say, as we were walking back to the vehicles, we hadn't made contact with anybody, and I happened to just look over and notice that the garage door was pushed open. And I thought, in my mind, I thought, people use earbuds and things, maybe somebody could be in there doing something, and didn't realize we were there. So I asked Deputy Cook, reckon we ought to go over there and make sure nobody's in the garage that didn't hear us. And he's like, sure, while we're here, might as well.
Hey, did you call out for people?
No,
You just went in the building and looked around?
no.
How
No.
did you do it?
Like I say, we started up toward we were walking toward the garage, and about 6 feet out from the threshold of the doorway, we smelled a very loud, I guess, smell of marijuana. And, which is odd, but so we proceeded up to the threshold. We never broke the threshold of the door, but we proceeded up to it and looked around, didn't see anybody. And, while Deputy Cook was scanning, he saw that tote with the stems, and he just pointed up. And so we right then backed up, even though we had never broke the threshold. But we backed up a few feet. He called Mr. Stevens, our county attorney, and talked.
So the original question was, did you call out to anybody in the building?
No,
Okay. And as you were approaching the building, you said 6 feet out, you smelled a strong odor of marijuana?
5-6 feet, yes.
Now, Garrett Smith testified earlier, and he said he smelled a slight odor of marijuana. Were you guys smelling the same weed?
Well, here's the thing. Mr. Smith didn't go with myself and Officer Cook. He continued on to his car. He was calling his supervisor. He was doing his own thing.
Okay. Well, he said later he came to the threshold of the building and said he smelled a slight odor. I guess it's not significant. I'm just curious as to why he said slight and you said strong.
It could be because by then we had already removed a large quantity of what was in the building.
And you had removed it before you got a search warrant, right?
That day, yes.
That day. Okay. And then how many feet again is the building from the pathway that you took as you were returning to your vehicle?
I'd say roughly 20, 25, 30 feet-ish.
No further questions.
You have any additional questions? He may be released. Thank you.
Thank you, sir.
Be excused. Mr. Russell, you can have a seat there somewhere if you'd like.
Thank you.
Yeah. Raise your right hand. You swear the testimony you're about to give us the truth, whole truth, nothing but the truth.
I do.
Sit down and say your name.
Austin Cook.
Deputy Cook, by whom are you employed?
Do what?
By whom are you employed?
Monroe County Sheriff's Office.
How long have you been employed here in Monroe County?
Almost a year.
Have you had any prior experience?
Yes.
And where was that?
Allen County Sheriff's Office.
How long, what did you do there?
As a deputy.
And how long did you serve as a deputy in Allen County?
Approximately 7 years.
So how many years experience do you have?
Right at 8.
Right. Would you start out at 16, age 16? You look
18.
young to have 8 years. You know why we're here today. We discussed the search that was made at Mr. Russell's premises back in December of last year. If you would start and just tell the court what you did right after you and the officers arrived, where you parked, and what you did right after you parked.
Upon arrival, we parked just off the edge of the blacktop to the right side of it, make contact at the front door. Nobody come to the door.
You walked to the front door.
Yes, sir. Then
Nobody answered.
that's correct.
What happened then?
Then we walked around to the back side of the residence, tried to make contact. There, we were unsuccessful with anybody answering the door. On the way back to the car, we
When
noticed,
you were walking around the house, did you search anything on the way? Stop and look at any in the bushes or stop and look at anything, or did you just make a straight line?
we just made a straight line.
After you, after nobody responded at the back door, then what did the three of you do?
We noticed that the garage door was open.
Where were you going when you noticed that?
Back to the car.
Right. When did you first decide that maybe these children that you were looking for might be in a garage?
Can you repeat that?
Do you think maybe the children that you were looking for might be in the garage, or that Mr. Russell might be in the garage?
Yes.
So where were you when you first thought of the garage?
When we got out of the car, you could tell the garage door was standing open.
So you knew coming up that the garage door was open?
Right.
But you didn't stop and search it then, did you?
No, sir.
So what made you search the garage?
We had no contact at the residence. So we figured somebody might
At
be in
some
there.
point.
Let him finish his answer.
Oh, I'm sorry.
We figured since nobody answered the door and the garage was standing open, somebody might be occupying that, was unable to hear us knocking at the front door.
Right. And how close to the garage were you when did you detect, you or Mr. Did either of you detect any odors that got to your attention?
Yes.
And what was that?
The odor of marijuana.
And where were you when you first detected that? Who first detected that odor? You or Mr. Shirley?
Mr. Shirley.
And how close were you all to the garage when did you detect it as well?
Yes.
How close to the garage were you when that occurred?
When that occurred, we were probably 10 foot from it approximately.
Had you been in the garage before you smelled it?
No, sir.
Did you recognize the smell immediately?
Yes, sir.
Had you smelled that before?
Yes.
And once having recognized the smell, do you know where the smell was coming from?
Yes.
From where?
The garage.
And once you recognized that smell, what action, if any, did you take?
None at that exact time. We observed the gray tote sitting in the.
Okay, you looked in the garage.
Yes.
Had you looked in the garage before you smelled that marijuana?
No.
Had Mr. Shirley?
Not to my knowledge.
Did you, I believe that Mr. Shirley said that you perhaps called the county attorney's office seeking legal advice.
Yes.
And you were told that based on what you were describing, that it was an open view and you had the right to look and search.
Correct.
And you did.
Correct.
And Mr. Shirley has told us what all he found and photographs of it. At some point, Mr. Russell arrived. Then tell us what you did.
We made contact with Mr. Russell.
He drove up, didn't he?
He was in the passenger seat of a vehicle that stopped in the road and got out.
Okay. Who was driving, do you know?
I'm not sure. They didn't stop.
Male or female?
I can't remember.
All right, go ahead.
And then myself, Deputy Shirley, and DCBS made contact with Russell. And Mr. Smith just started asking a few questions about the complaint that he had received. Mr. Russell did state that he did smoke marijuana. At that time, we advised him that what we'd found in the garage. And,
Oh, he didn't know at first what you all had found.
correct.
All right, go ahead.
I advised him he was under arrest, read him his Miranda warning. He then gave consent to search his residence.
All right, did you all go into the interior of his residence?
Yes,
When did he give you consent to search?
while we were outside.
All right. Was any area of the residence that you didn't search?
Yes.
What was that?
I believe 2 bedrooms that had locks on the outside of them.
That was my next question. Why didn't you search those rooms?
Deputy Shirley searched the living room, and I searched what 2 bedrooms Mr. Russell claimed was his.
Right. Did he just tell you not to search the one with locks on it? He didn't give you consent to search them, right?
Correct.
So you didn't.
Correct.
All right. And then what happened after you finished interrogating Mr. Russell?
I located 2 bags of marijuana inside of a backpack in one of the bedrooms. Mr. Russell took ownership of the 2 bags I located inside the backpack.
Did you find a suspicious white powder somewhere?
Deputy Shirley did in the living room.
What did Mr. Russell have to say about that?
I can advise I wasn't in there at the time it was located.
Okay. At some point then, after you had discovered what was in the house, what did you all do?
And then transported Mr. Russell to the Monroe County Sheriff's Office.
For the purpose of processing him?
Correct.
And was that at the sheriff's office or the city hall?
Sheriff's Office.
All right. Well, while there, were you both seated at the same table?
Yes.
Had you all let Mr. Russell still keep his telephone?
Yes, at that time.
Objection to relevance, Judge, as to.
Let's move on.
Did you let him make a call?
Yes.
How close to you were Mr. Russell when he made that call?
I was sitting here, his back was all the way up against the desk I was sitting at.
Could you hear the conversation back and forth?
Yes.
And tell the court what the conversation was.
Mr. Russell was speaking to a female, and she asked Mr. Russell, did they get all of it? To which he replied, a lot of it. The female then stated, what about the money? And then Danny responded, no.
All right. After you heard that and realized maybe that you didn't get it all that first day, what did you do?
And then obtained a search warrant the following day.
And you got a search warrant for the premises?
Yes, sir.
Everything?
Yes.
Cars, buildings, everything?
Everything.
And what did you find in searching the cars?
Upon arriving that day, I made contact with Mr. Russell in the front yard. I asked him if I could step inside the residence with him and the 2 other occupants that live in the house, where I read the search warrant aloud. He then immediately escorted us back outside to a black pickup sitting in the yard. And
is this a junk pickup or a pickup that runs?
I can't advise, there was some vehicles.
Go ahead.
He immediately opened the door, started throwing duffel bags out.
He did?
Yes. He stated, this is what you all missed yesterday. And then once he got done taking what marijuana was inside that pickup, he immediately shut the door. And with that search warrant, that vehicle was covered under it. Deputy Shirley opened the passenger door back up, and there was some AR magazines in the door. And behind the seat was a black Bushmaster AR-15.
Did Mr. Russell say anything about the weapon when it was found?
I don't recall.
Okay. But it was in the vehicle that he had taken you to?
Yes.
Have no further questions, Joe.
You may inquire.
Deputy Cook, I've just got a couple of questions. Who made the decision to go search or look into the garage?
We didn't search it until we spoke to the county attorney. We made to see if we could make contact with anybody. Once we left the residence, the door was standing open. We figured it was right there. We just see if anybody was in there that wasn't able to hear us knock on the front door.
Can you describe the door? Was it a garage door or a walk-in door?
It was a garage door, but it was one that slides, not
Okay.
raises up and down.
How many feet away did you say you were before you could smell marijuana?
Approximately 5-10 foot.
Okay, and then how far is that garage from the path you took to leave from the back door to your vehicle?
The path from the back door to the garage?
Okay, so you went to the front door,
Correct.
you went to the back door.
Yes, sir.
When you're at the back door, you were gonna go to your vehicle.
Yes,
There is a pathway between the back door and your vehicle.
yes.
How far is this garage from that pathway from the back door to your vehicle?
Sure, approximate foot, but it was, or sits in front of the end of the blacktop where we were parked.
10 feet, 20 feet?
Approximately 20.
And who actually saw marijuana in the vehicle and the truck on the dashboard?
I did.
Okay, and how much marijuana was that?
Just a couple, I mean, not a lot at all on top of the dashboard.
Okay. And then this is a stupid question, but I just need it for the record. Would you have been able to see from the Acresville Road? Standing there, would you have been able to see any marijuana in that garage?
Standing from the actual Acresville Road?
Uh-huh.
No, sir.
And you couldn't have smelled it either, right?
No, sir.
Okay. Could you smell the marijuana from the front door of the house?
No, sir.
Could you smell the marijuana from the back door of the house?
No, sir.
Did you see the marijuana from the back door of the house?
No, sir.
Nothing further.
You have another witness?
No, Your Honor.
Okay. You want to make your argument? On you, I guess,
Judge,
you can be excused.
here if we brief it, give me like 5 minutes. I want to weave in some of the facts from here to the brief just for possible appellate purposes.
Well, I'll let you brief it if you want to, but you want to be heard or you want to just brief it?
Well, I
Or both?
heard a little bit, now,
Okay, let me hear you a little bit.
because this is a unique case, we are actually talking about 3 searches on Mr. Russell's property in the course of 2 days. The first, as you heard, was the search of the garage, and testimony is without exception, it's what it is. They had, number one, and this is the overpowering part of the whole scenario, is that those officers had a right, and I would assert they had a duty to be on those premises. They were there lawfully. They had a right to go onto those premises. They had a right to go to that house. They had a right to go to the back door. And as they were exiting back to theirs, there was no evidence, not a hint of evidence, that they deviated from that course and ransacked or went off of it, searched any other buildings, didn't look into any of the cars. They were headed back to their vehicle. And I submit that under those circumstances, that this was a proper search. And of course, it's going to turn on an issue that's been litigated in this country, I'd say millions of times. And that issue is going to be whether the garage is part of the curtilage. And I submit that more than distance is involved when you determine whether an unattached building is part of the curtilage to the house Because the curtilage has always been that the building complements the residence, that it makes the residence more livable and more comfortable. But it does not apply to a building, even in the proximity of this one, that's being used for illegal purposes. And the facts are that that building contained anywhere from 60 to 50 pounds of marijuana that you've seen pictures of that came out of it, and that there is no way that that would be part of the curtilage. That not being a part of the curtilage, there's nothing wrong with this search. Case law is, of course, all over the place. The case law that as previously cited was officers at a place that was simply a knock and talk. They just haphazardly stopped at a place and knocked. There was no objective to that. And that case does not define what is the curtilage and what is not. Where these officers had a right to be there doing their duty, they have a right then to use their eyes or their nose. And when their senses detect something like marijuana, they have a right then to seize it. Now, it's one second, Your Honor. I wasn't prepared to make a question.
Well, I'll let you supplement your statements now by a brief if you'd like. I get the gist of what you're saying.
If I could just have 1 minute, Judge. If he's done.
I'm not done. If you look at me a little time. Yeah, the evidence is clear, and it's without doubt that the garage door was wide open. It was from the drive that they were walking down toward their car. It was easily visible. There were no fences around it. There were no signs saying this is private property. Stay out. There is nothing in that scene there that shows that Mr. Russell made any effort whatsoever to establish a reasonably held doubt, a reasonably belief that he would be entitled to privacy on that garage.
Judge, if I could just have 1 minute.
You can have more than that.
Thank you, Judge. Briefly, Judge, this case turns on something different than the officer's right to be there. Certainly under Floor versus Commonwealth, an officer has a right to be anywhere that he's supposed to be. In that case, it was an investigation of a stolen four-wheeler, I think. The officers came up to a broken fender. They understood it matched the identification of the stolen four-wheeler. But this is something entirely different. The nature of the intrusion upon the Mr. Russell's property was for a DCBS complaint. The officers themselves, they were not, they weren't obliged to go to this property to conduct an investigation.
Well, let me ask you something. I think that actually goes against you a little bit, unless you can explain it away. Do you think that these social workers have a right to bring officers with them if they have fear or trepidation of what they might be running into?
Judge, I don't dispute that they can do that,
Okay.
but I
so
think
if-
the
if-
breadth
If
of,
they do that, then if they're just walking up through there and they run into thing in plain view, it's not like a search or anything. They're just there on official business and they smell this marijuana coming out. If they did that, I don't know, you know. If they smell this marijuana and they see marijuana up there, does it change the situation some?
well, Judge, I guess what I'd be saying is this, the breadth of what their role is when they go to a crime scene is to investigate.
So this is not a
The
crime.
breadth
scene.
of this would have been just merely to escort DCBS.
So if they see something while they're properly escorting them there, they should completely ignore it? Or I don't smell that, I don't see that, you know?
From their perspective at the vehicle where they allegedly saw the marijuana on the dash of the
Yeah.
vehicle,
Yeah.
at that point, they should have obtained a search warrant.
Well, I mean, they walk on up through there on the way out and they smell the marijuana coming out of the building. They say they do. I don't know whether.
Well, they said part of that. They said within 5 feet, 6 feet, or even 10 feet of the building, they could smell marijuana. But the pathway was not 5 feet, 6 feet, or 10 feet from the building. The pathway was
They said
allegedly
they were-
20 feet.
They were looking for somebody to respond to the social workers, what they said. I don't know.
Understood.
I understand what your theory is. You know, you're saying that they weren't there for an investigative purpose with some kind of articulable suspicion or anything. They were there for another purpose, and it should limit them on what their scopes. What you're saying is that what you're saying?
It should limit them on their scope.
Yeah, that's what you're saying.
But if they've had some probable cause at the time from a dashboard, then certainly they could have gotten a warrant before they entered the premises of a building. But from even their viewpoint there at the building, they couldn't have seen what was in the rafters. So if the court would permit us to brief it, we would be grateful.
Okay. How much time you want?
10 days, Judge. I need to get a copy of the hearing and then go through it and then draft the brief.
You can probably get the copy sometime today. Can you get a copy of the proceeding today? Yeah. So,
10 days, okay.
yeah, it's fine. You want 5 days to respond or 10 days to respond? 10. Okay, that's great. Well, thank you all for your diligence. Okay, that concludes the business of the Monroe Circuit Court. We're in recess until 1.
No.
No. No?
We're not done.
Mr. Underwood, he's been here since about 9:45. He's the one that we had a bench warrant get issued. He's here for final sentencing.
Mr. Gregg?
Danny, it would be best not to say anything. I'm going to come and see you.
Okay.
Okay. Thank you, Barron County. You're released. Now, you have somebody in Barron County?
No.
Mr. Underwood.
Yeah. He was one that didn't show up earlier. Okay. Yeah, I'll withdraw the bench warrant. No. No. Right, what this? I'll lose this if you don't take it.
I'll get it in a minute.
Okay.
Yes. Yes.
Okay, are you William J. Underwood? Hey, what's your year of birth, Mr. Underwood? Okay, you're here for the purpose of sentencing today. You understand that? Have you had an opportunity to review the pre-sentence investigation report number of probation and parole? Is it substantially correct?
Judge, we have corrected certain aspects of it,
They
contacted.
will tell me what they are.
Yes, sir.
Probation and parole's already gone, aren't they? Make notes of the changes. Would you do that? What are they?
For example, updated a phone number for the 126 Coakley Road in Greensburg for his current or last address.
Change of phone number is one of them. Okay, go ahead.
His education, highest education level is 8th grade, and he got a GED.
Okay, that's not on there.
Sorry,
It's not on there that he has a GED?
it is not. It was just 12th grade, Judge.
Okay, well, and he's got a GED. What else you got?
He is working on obtaining disability under the unemployment.
Okay,
And then under the family members, it's Cindy Underwood, not Renee. Same address as Mr. Williams, Underwood, and then an updated phone number.
okay. Besides that, is everything else substantially correct?
And then one final thing, he completed drug court in 2022 in Campbellsville, Kentucky. It just had a treatment program, but that was specifically drug court.
Okay. Okay, if you'll list those additions, the Commonwealth has no objection to them being supplied directly to probation, parole, and then the precinct's investigation report.
Yes, Judge.
Is there any other reason why this gentleman should not be sentenced today?
No, Your Honor.
On a plea of guilty possession, first degree and second offense, methamphetamine, he shall receive a sentence of 3 years, probated for 3 years, supervised. But on a plea of guilty to operating motor vehicle under the influence, he shall pay a fine of $250 in cost. He shall receive credit for time served. Obviously, he's not able to seek gainful employment, but should do so as soon as he's able. What is it? And when you pled guilty on this DUI, you knew it was enhanceable. If you get another DUI, it could be more serious. Is that correct? Yeah. Okay. And the felony is enhanceable too. If you get another felony, correct? Okay, what's the court cost?
$635.
$635. You need some time to pay that? So you said the fine and court costs on your DUI and everything is
I think
$635.
that's just the court costs. I don't think that includes the fine.
$200 fine, also next.
Paid 85. Okay. You need some time to pay that? I'll let you pay it $50 a month, starting 30 days from today. Okay? You need to meet with the probation and parole officer. I guess, can one of y'all call probation and parole and say he's here?
I can, Your Honor. I can let Mr. Collins know.
Okay. If you'll just wait around here at the courthouse and the probation parole officer will call here and tell you where you need to get, he needs to get information to set your probation up, okay? Okay, thank you very much.
Thank you, John.
And then Judge, Mr. Lee Davis asked DPA to stand in. He had to get to Hardin County. It's the Taylor County arraignment for Miss Carmichael.
Just do past next month. They never got on Sunday.
We will let Mr. Davis know.
Okay, thank you. Okay. Show cause docket. Commonwealth of Kentucky versus Mark Lee. We what? Hadn't paid anything? Is this restitution or fines? Y'all know Mark Lee? Do a bench warrant, he can purge himself. He's supposed to pay how much a month? 30? Let him pay $200. How long's it been since you paid last 3 payments? Since ever? Okay, let him pay $300. Tamia Trammell? Never paid anything? Bench warrant, let her pay $250 purge it. The direction paying. Doyle, y'all, is that the entire show cause?
Yes.
Okay, what do y'all have?
Stuart Whitley, he's on show, he should be show call, Ron. Stuart Whitley.
Stuart Whitley.
That's that's the one I'm trying to work through that's on parole.
Wait a
He's not
second,
on the
wait a
show.
second.
He's not on the show plus. That's the one on parole that we're trying to work through and figure out.
He's on parole, so he's not on a show cause thing and he hadn't paid his restitution, so we're trying to work through it. Who is his attorney?
It's a 2014 case, so.
Okay, I think he needs representation in the thing. I'm gonna appoint public advocacy to interview this guy and explain the situation. He has court costs or restitution,
Restitution.
has restitution, and he's still on parole. So y'all need to interview him and get his side of it, okay? We're holding him on that, correct?
Yes, I think he's got a $500 warrant on show cause right now.
And it's on the show cause docket last time, a $500 warrant. That said he could purge himself if he paid it. So y'all need to maybe look into that, meet with probation and parole, because they might revoke his parole over it. They could. Okay? You talk to your lawyers over there, okay?
Stewart? Yeah, STEW or STUAR?
Is there anything else?
So one of us will come.
Okay. It's lovely. Steven, how y'all doing?
How are you?
Blessed. Spend most of my time trying to keep up with my phone. Okay, let's start down through here. Davis versus Adams.
You do September the 17th, please.
Okay,
No,
No, that's not our case. That is filed by
Michelle Fisher.
Michelle Fisher.
Michelle Fisher, are you on the line here?
This case, it's also on at the civil docket, so I don't know.
Well, we'll just pass over here. I'll tear it up and we'll take it up over there. Burge versus Burge.
September 17th, please.
Bird versus Bird again,
Continue.
17-0-0-0-0-83.
September 17th.
Caps versus Caps.
You start Ms. Table in, please.
Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes.
Okay.
State your name for the record, please.
Taylor Staples.
Employed by the Monroe County Child Support Office. You're familiar with Monroe Second Sports Election number 13 CI 119. Is that correct?
Yes.
Hope Caps came to our office requesting that a child support obligation be set for the child. Is that correct?
Yes.
And you had done the calculations, and based upon the Kentucky Child Support Guidelines, it should be set at $198.50 per month, and you're asking that to be retroactive to August 1st of this year.
Yes.
Okay. Submit the order electronically. Crawford versus Crawford.
Continue to September 17th, please.
Russell versus Curtis.
Continue to September 17th.
Donaldson versus Donaldson.
Continue to September 17th, please.
Okay.
September 17th.
Fox.
D. Fox. Going to outlive my tenure. Yeah.
Maybe all of us.
Yes.
Graves versus Graves.
Continue to September 17th, please.
Turner versus Guffey.
Continue to September 17th, please.
Hammer versus Hammer.
September 17th, please.
Hassett versus Hassett.
September 17th,
Taylor versus Houchins.
September 17th, please.
Hudson versus Hudson.
September 17th, please.
Jimenez versus Jimenez.
September 17th, please, for review.
Dye versus Jones.
September the 17th, please.
Muse versus Muse.
You're still under oath. You're familiar with Monroe Circuit Court case number
Speak up just a little bit.
26 CI 61, is that correct?
Yes.
And Mr. Muse is before the court and given notice of this hearing, is that correct?
Yes.
And he has an arrearage of $24,170.36, is that correct?
Yes.
And he did make a $50 payment on August 12th of this year, is that correct?
Yes.
And as far as you're aware, his financial condition or is not incarcerated as you testified at the previous contempt hearing, is that correct?
Correct.
There was a contempt order entered on July 16th, 2026, and he did not make the necessary payments to purge himself of that contempt, is that correct?
Correct.
Okay, submit order. Muse versus Muse. This would be Ronald Muse versus Tina Muse.
September 17th, please.
Pennington versus Pennington.
September 17th, please.
Rich versus Rich.
September 17th, please.
Smith versus Smith.
September the 17th.
Child support docket. Thank you very much. Let's go to the civil docket.
The first case on is that one with the child support.
They're taking off. That's it. There's just Adams taking off.
No, the first one, it's the one that had the child support motion.
Okay. It's when they took off. Yeah, I got what you're saying. I'm gonna call 26 CI 0001 Jerica Davis versus Justin Adams. Hello? You are Justin Adams,
Yes, sir.
Jerica Davis. What do we have here?
Your Honor, I had filed a motion for default, which was on for the last motion hour. And then you'd instructed Mr. Adams, he asked for more time to get an attorney. He was given 10 days. And then you'd indicated to him to be prepared for a hearing. To my knowledge, he doesn't have an attorney. I had given him a proposal out in the hallway. He was still thinking about it as of about 60 seconds ago. I'm not sure if he's made a
What
decision.
proposal did you give him?
We had proposed, Your Honor, some supervised time to start with. There's some substance use issues that he's currently dealing with and working out.
How many children are we talking about?
One child in
One
common.
child. How old?
5. He just turned 5. Just entered kindergarten. So she's proposed hours of 4 to 7 on Wednesday evenings, supervised with the parties to work out.
Did you try to get an attorney?
I did, I could not afford one.
Who did you talk to?
I called around,
No, I want to know who you talked to.
well, I called Nick Carter's office, but he's deployed or something, I think.
Yeah.
I couldn't get a hold of him, and then, there was I can't think of his name, another Turner or something from Glasgow. Couldn't afford
Well,
him.
I want to give you every opportunity to have somebody represent you. I think I've done that. You know, I don't know.
I just couldn't afford one. At the time they were there.
Well, you might not be able to afford one, but you might, you could get hit with something, you'd be paying a hell of a lot more over a period of time than it costs you to get a lawyer.
I just get. Yeah.
Well, I mean,
Yeah.
you say you can't, but people find ways. Are you working anywhere?
Yeah, part-time.
Do what?
Part-time. Yeah.
Why are you just working part-time?
But that's the only hours I can pick up.
No, I can call right now and get you 5 jobs here in Monroe County. People are hiring, they can't find anybody to work. I mean, you are the author of your own problems here out of the situation. So what do you propose? You
Your Honor,
want to go out and talk to him for a few more minutes, see if you can work something out?
Yes, Your Honor.
Okay,
Thank you.
I'll call the docket back. Okay. Bitterfoot Rivalti versus Donna Barkley.
Good afternoon, Your Honor. Morgan Wills for Bitterroot Rivaldi. We're just asking to have a guardian ad litem appointed for Donna Bartley. She is in the Kentucky Correctional Institute for Women. And under CR 17.03, a guardian ad litem needs to be appointed for her.
Yeah, we'll do that. You got the list up here with you? Well, get somebody local around, from Berksville here because, okay, we'll sign an order.
Good job.
Wait a second.
I will just point out that I believe she's serving time from here, so it doesn't need to be anybody associated with the prosecutor's office.
Okay. Avoid the prosecutor's office or anybody that is a prosecutor because she's serving time from Monroe County. So we'll have to go to another county. You do Holly Page and she can do it. She's not associated. Okay, thank you very much.
Thank you, Your Honor. Have a good day.
You too. Gerald's versus Cornelius. Margaret Gerald's versus Jonathan Edward Cornelius and others. Okay, what do we have here?
Judge, if you recall, this was on last month, and you did determine that Miss Gerald was the de facto custodian. This was on mom's request for visits. Our position continues to be, there's an open and active case in district court involving abuse or neglect with regards to mom. So the cabinet is right now designing and implementing what they think is appropriate for her contact, and we're just asking that that continue. Right now, what she has is phone contact while the child is in therapy. I have a letter from the therapist saying that she believes that's appropriate and should continue.
Have
I've
you
also
got
got,
an attorney yet?
I don't know if Candy. I received an email this morning from Candace Combs saying that she has been retained, but that she was just retained and she is in Virginia attending a funeral today. Sorry.
you just want to set it for next month, Judge?
Set it for next month. And do you have Ms. Combs' address or anything you can share with council?
Judge, I know who she is. She's fairly new, but she's got an office in Glasgow.
Oh, she does have an office in Glasgow?
I think so. I don't know if it's a physical storefront, but that's primarily where she seems to be popping up.
Yeah.
So.
She does gospel music stuff. She's a promoter in gospel music. And what's that group that's over there? Had a florist.
Jeff, Sneed, yes.
You what?
Sneed.
Yeah, the Sneed family. I knew them well. I just had a blog. That's probably a reason she's over there. She's been associated with them. Well, if you'll share information, we'll put you on. Why don't you have your attorney call counsel here and see if y'all can talk and set something up maybe other than the rule day. The next rule day is the 17th if you can't work anything out. Okay?
Thank you, Judge.
Okay, thank you very much. One Main Financial Group versus Crow.
Yes, Judge. This is Julie Gordon on behalf of the plaintiff.
I didn't know we had anybody covering this one, Judge. This is Justin Hamilton. I work with Leaker Brody and Andrews, so I'm here as backup. So I'll go ahead.
Two days in a row was.
Oh, is this Gordon?
Yes, it is.
Yeah, I'm just gonna start traveling with you, I guess.
Okay,
I'll let her take the lead on this, Judge.
Okay, you're Mr. Crow, is that right? You're Mr. Crow?
Yes, sir. I'm sorry, I'm hard of hearing, Judge.
Okay, well, get him some of these hearing things over here.
You come over here, man, you don't turn on the microphone.
Well, no, the microphone won't help him
I
hear.
mean, I want to make sure you just get him on the record.
Judge, let me know when he has the headset on.
Okay, wait just a second.
Thank you for your service.
Wait a second.
Thank you for your service.
Thank you for smoking.
This is one we want to check the file, see if it serves. This file here.
Yes, sir. Thank you very much.
Here you go. Okay, well, first thing we're gonna do, is that better?
Yes, sir. I got it.
Okay, first thing we're gonna do is there was an allegation that there wasn't service or summons, so we're gonna check the file here.
Service was. This one's no contact.
Judge, if it helps, it looks as though proof of service was filed of record on September 9th of 21 by the sheriff.
We're looking at it right now. We're looking at it right. Okay. Is he in that service? It's your notations. This, I don't know whether these were done beforehand.
Yeah, so it looks like 628.
And they served it on this day. Well, there's a proof on the summons. Somebody's got a microphone on that they need to turn off. On a proof of summons, there were a couple of attempts noted on the summons. And then the former deceased Sheriff Ford said he served it and has a proof of service that he served it on you. So the proof of service seems to be sufficient. What you say you don't know anything about this debt?
No, Your Honor, I know that I had a debt. What would happen was that there was I had filed for bankruptcy a couple years ago, and then I ended up losing my job. So I was unable to continue to make payments, and it ended up getting dismissed. It was a chapter 13. Since that time, there was a couple of people that I still owed money to that had reached out to me, and I'd made payments to those gentlemen, and I paid them off, but this wasn't one of the locations that had reached out to me, so nothing was ever set up. And then, nothing was told to me again until after the money was just garnished out of my account, which is why I'm here today without legal counsel.
Well, the record says you were served with this complaint, this thing.
And Judge, if I may just add to it, he's correct on the bankruptcy filing of chapter 13. And when that case was dismissed, we got the notice of it being dismissed, and then we just reactivated our execution of the collection efforts, thus the garnishment placement.
Yeah, there was.
In terms of notice, it appears that the plaintiff was listed as a creditor in the bankruptcy that was filed by the defendant. So, he clearly knew of the debt because it was listed as a creditor.
That's correct, Judge.
How much, let's take a look at what you're charging him as for is.
It was a little over 15,000, Judge. It was,
What was the underlying debt?
oh gosh, this was an automobile.
No, it was a personal loan from several years ago, right after I got out of the
The
military.
default judgment was in there 5 years, almost 5 years ago.
Yeah, default judgment was entered 5 years ago. What are the bill of costs that you submitted?
I didn't have that with me. I apologize. I can see if I can pull that up.
That was done 5 years
Yeah,
ago.
it was all litigated all.
Yeah,
And then it got stayed because of the bankruptcy.
yeah.
Oh, yeah. So I don't see a bill of costs actually filed in this one. Let's see if it was with the it could have been attached to the default judgment from back then. You open that up.
Default judgment was entered 5 years ago. There was a temporary stay issue because of your bankruptcy. And when that was lifted, it was in place then. So it's been over 5 years. There's nothing you can do about that. But I will take a look at what they've charged as far as collection costs and that sort of thing.
Yes, Your Honor, I'm not looking to try to eliminate any debt whatsoever. I'm looking to pay my debt. I'm just trying to make sure that I'm capable.
It looks like the principal was 13,449.40. Interest was 1,898.27. Attorney's fees were $587.
$585. That's a bargain for you, man.
What was that, Your Honor?
12,000 is something debt plus the interest on it, and they just charge you 500 and something dollars attorney's fees. So, I mean, that's a bargain for you. So they're here, you just need to I'm gonna deny your motion to set it aside, and you need, while they're here, it would be a good time to see if you can set some payments up with them.
Yeah, that's what I've been trying to do.
Okay, well, you got an attorney here to, you
sir.
work with him,
I've
maybe
got
him for
authority.
me.
Yes, sir.
Okay, thank you very much. You get those earphones. Thank you.
Thank you, Judge.
Would you let me come back in and?
Yeah, come back in and
Okay.
report. Good, see if you work out anything. Be
Okay.
good.
All right, sir.
Okay,
Thank you,
Owen versus Denton.
Your Honor, we have agreed to pass that. I think we've got a mediation date set up to try to
That'd be
resolve
great.
it.
That'd be wonderful.
Yeah.
What?
Next week, we're
week.
gonna do
That'd be
that, so
good.
we'll
Okay.
just redocket it if we're not successful.
James Montel McClendon versus Carolyn Marquita Hall.
And Judge, I think we received the report from the friend of the court about 30 minutes ago, so we've not had a chance to review it or determine if we need to hear further from her. So I think what we are thinking is just put it on next month's docket. That way, if we need to hear more from her, we can do it at that time. Yes.
That'd be September 17th.
Yes, sir.
Okay, that'd be fine.
Thank you, Judge.
Page versus Houchins. Okay, says moves the court to conduct a hearing to determine where the minor child shall attend school.
So this was filed as just a custody action because the parties, they just by agreement done 50-50 up until now. But I think they probably are still gonna be in agreement on custody and time sharing, but mom lives in Barron County, dad lives in Monroe County. They can't agree on where the child will be enrolled in school, so we're gonna have to have a hearing on that. And school,
How old is the child?
she's four.
Preschool.
She's 4.
Well, she
Yeah.
doesn't really know where she wants to go.
Well, she's not gonna know, no. That's why you're gonna have to, you're gonna have to help us decide. So,
Monroe County, next case.
okay.
Just kidding.
Judge, my other case got called exactly the same time. I'm just continuing for two months. Can I tell Judge Ballard, continue it for 2 weeks? He's calling my name.
Well, go ahead. Step out if you want to talk to him.
Well, he skipped me. It's okay. He'll call me back.
How do you decide this, you know?
I mean, there are cases that give the court a list of factors to consider. So, I mean, honestly, we could probably do it by written memorandum if you wanted us to. I don't know if you want to hear testimony. I'm not sure.
Judge, I think we could have a hearing in an hour possibly.
When you want to do that today?
Not today.
It's gonna have to be today or really quick because preschool
Yeah.
starts in about a week and a half.
Preschool's already started. This kid's going to both schools.
Well, good, get a double
No,
education.
preschool hasn't started
Oh, it
yet.
started in Barron County.
Preschool
She's
hasn't.
going to Barron.
Just regular school started there.
She's gonna be in preschool.
Yes.
Where the grandparents live? 2 sets of grandparents. Are they
I think 3
involved?
of the 4, okay, your parents are here.
My dad lives here. My mom lives in Lexington. My little girl's grandpa lives here. And then her other.
I think 2 grandparents live here. One lives in Barron and one lives in Lexington.
Yeah, my grandparent is the mom. This maternal side is, she works and lives in Barron County. Mama works and lives in Barron County. Grandma's a nurse practitioner. Mama's a nurse at TJ. Of course, dad's here.
And mom's dad lives here.
Then they got
Mom's
great.
dad lives
Yes,
here.
and the
Mom and
mom
her,
lived-
and
mom lived
mom and
here.
her mother live in Glasgow.
And yes, and then dad and dad's dad all live here. And the parties lived here when the child was born and they were together. Then mom relocated to Barron County.
And then they got grandparents live in Metcalf. Tommy.
Oh, sure, name drop. I see what you're doing.
The clerk.
Yeah.
So there are 3 counties. But my client lives in Barron County and has for a number of years.
And I don't know if you want to hear more. I mean, I'd be happy to lay out why we
I
think.
want them to agree on it.
I know, and that'd be in a perfect world, that would happen, but we tried, and I think that's just, everything else, everybody has played very nicely. But this seems to be a.
How about let them go to Metcalf County? That's like, you're like Solomon deal is.
Split the baby.
Okay, we can schedule a hearing, but I guess, what do we like here next month? We got anything much yet here?
I don't think we have a 2 o'clock here.
Let's
And I don't know if that will mess up the child
I'm
enrollment.
sure it's gonna mess up the child. Anytime people wait this late to have a hearing on this, it's gonna school start. You know,
What day did you say next?
well,
One day?
what am I doing tomorrow? You wanna do,
I got a hearing in Allen County, but not sure how long it starts at 9. Don't know how long it's gonna last.
what about
Shit, I've got a
Zooming?
hearing
What
in
about
Metcalf.
Zooming something tomorrow?
I mean, I could do tomorrow afternoon.
Am I doing anything
I'm in
tomorrow?
Barron County in the morning.
Let's Zoom something tomorrow afternoon. How many witnesses you gonna have?
I think it'll just be the parties.
I'm gonna have a couple of witnesses, Judge. So quite frankly, I don't know if I can get the school personnel by Zoom tomorrow.
It'll have to be in the afternoon since we only have 1 courtroom,
Yeah,
whatever we do.
But we got a hearing.
it's Thursday. What have we got on Thursday?
Oh, tomorrow's Wednesday, right?
What about Thursday?
Yeah, I do have a trial tomorrow. No,
Thursday.
Oh, we do have, we have court in Metcalf Thursday.
Yeah.
I have a trial tomorrow afternoon, but I have a
You
trial
said
on Thursday.
yes. You have family in Metcalf County? Your wife has family in Metcalf. Who has family?
Mom. Mom's,
Former, not your wife, but the mother child has family.
mom's granddad. So child's great granddad.
That's really, I knew I got Mid-Cape County somewhere.
Metcalf is where.
He was trying to name drop.
Yeah, Tommy Garrett. That's the parent, the clerk. That's the great grandparent. I guess his wife.
Great grandparent. Well, first thing I want y'all to do is, as soon as you can, send us a copy of the factors that I'm supposed to look at.
Okay.
And then let's limit the testimony to those factors. Now, have you got your calendars out yet?
Yep.
I got it out, Judge.
What's Thursday look like?
This Thursday.
Because this Thursday is when I do have my Allen County trial, and then I have we have a hearing, we have a hearing together Thursday afternoon in Metcalf. So
At 2. What time's your Allen County?
it starts at 9, and they sort of contingently put our 2 o'clock on.
Well, let's look at. How about Friday morning?
I've got a CAPTA hearing, Judge. Problem with this week is I've been on vacation and never pays to go on vacation. So everything that piled up on me is, I'm trying to get rid of this week.
And you said, what do you have going on tomorrow afternoon?
We have a hearing. I have my trial starting at 9. No, tomorrow afternoon is, I got a divorce trial starting at 2 o'clock. No, starting at 1 o'clock.
You think it'll last over a couple of hours?
Shouldn't. It shouldn't. They get my witness.
Y'all pick a day. Y'all pick a day this week.
I think Mr. Hampton's the one needs to pick a date.
Well,
These have all been okay with me.
what about Monday?
No, I'm gonna do it this week. It's gotta be done. I don't wanna do the school start. I wanna decide and have a clean. What time what do your things start tomorrow? What time?
I have a trial at 2 o'clock, and then I have just family court in the morning, rule day, probably
Well,
DVO.
I guess I can do a Zoom on my iPad. Can I do a Zoom on my iPad?
The clerk can't record.
See, we're just down in one courtroom because of the flood.
Oh, yeah. I mean, tomorrow, I mean, we both have Barron in the morning, but usually we're done by about 11. So I mean, we could maybe.
Then I have my trial at 1.
I'm not gonna come on.
I wouldn't expect my CAPTA hearing to last all day on Friday, Judge.
I'd rather do it. What time y'all finish tomorrow?
I'll be done at 11.
Tomorrow I have start at 1 o'clock. I don't know what time I'll be done. It's a trial, divorce trial.
We also have morning.
District court's usually finished by noon over there. Well, it's not gonna be over an hour. This thing won't be an hour, will it?
I don't think so.
Well, I wouldn't think so. There's some dispute about the facts.
Yeah. Yeah, let's look at the 20th again, Thursday. What do we got on Thursday?
I have something from 1 to 2, 1 to 3.
Okay, what do you
Thursday,
have,
I'm
what do you have
unavailable.
that morning?
I have a trial in Allen County.
Wednesday and Thursday?
No, the trial
Thursday, we're
tomorrow's
on
in Barron
Thursday.
County. The trial tomorrow is in Barron County.
Thursday. We'll look at
Thursday's the
Thursday.
trial in Allen County, starting at 9 o'clock. And then I have the hearing with Holly
At
at
2.
2 o'clock, Thursday.
So what time are you gonna get clean in Allen County, you think?
Judge, she's pro se and I got a stack of papers. It's a special appointment because Judge Pence had a conflict. Oh, Judge is hollering at me here, Judge. Just hollering my name. Sorry, Judge.
Step out, it didn't bother me.
Yes.
Physical 30.
Sorry, absolutely.
What's the time split now?
They do 50-50.
I mean, but what days?
Thank you.
2, 3, so like Monday, 2 to the.
How's it gonna work anyway?
We would have to get creative on the time split, but I think they're both committed to trying to keep it as even as possible.
Yeah, they've worked well up to. this
Yeah, they really
point.
have, Judge, and like I said, there haven't been issues up until now. And they've.
Well, I know it had been school up until now.
Right, but I'm saying, I don't
So
think there's.
somebody's gonna get the child. I mean, whoever, if the school is in Barron County, they have to transport the child over there on the mornings they have school, or how does that
Correct.
work?
I think that would
that's
be where we
probably
would
what's gonna
start.
have to that's what's gonna have to happen, I think.
His client is a nurse, so she works like 12-hour shifts, so she has more days off, like she works long hours on the days she works. I would imagine what we would end up doing is trying to work something so that on her off days, if the child were in school here, she'd be able to transport the child, but she wouldn't be working. Like I said, I think both parents are committed to keeping it as even as they possibly can.
And I think.
If we
he's
can't get
self-employed.
it right to 50-50 during the school year, you'd probably flip it in the summer just to even it out. Something.
I think Ms. Coleman's client's self-employed, he makes his own schedule.
Well, let's go back to finding a day here. A Solomon day here. You were looking at what time y'all start on Thursday, wherever you are,
9 o'clock in Allen County.
and you're gonna be over there for a couple of hours.
I could not tell you, Judge.
Well, till noon, 3
I would say
hours.
that I'd be happy to be out by noon.
Well, I'll be happy to be out by noon too. And you're
We
gonna
got
drive
to-
from there to where?
Going to hearing and Metcalf at 2.
What's that hearing about?
School,
Ironically, school.
not where, just how the child's gonna
Yes.
attend school.
And how long do you think that's gonna last?
It's docketed for an hour. The court set it for an hour. I don't think it takes.
That's on Thursday?
That's on Thursday from 2 to 3.
Okay, well, while y'all are there, we might be able to make some arrangements for y'all to have your clients there and appear by Zoom in front of me on Thursday at 3 o'clock.
Okay.
Yeah, that way we can record it in Burkesville and both of y'all already be present there. Okay,
Yes. Megan, will you just send us a Zoom link? Okay.
I wonder if we can. The judge is not doing anything. If our hearing's over, is there some way we just get the courtroom so it's all?
Yeah, certain we're the last thing of the day because Katie, I know, has to leave.
I'm just trying to think, so you just kind of have the benefit of the courtroom, but you'd be on Zoom.
well, the only Zoom I can have is in my courtroom anyway, and we're just down to one courtroom.
Yeah.
Okay.
All right.
I mean, if I want it recorded, I do Zoom meetings all the time off my iPad, but it doesn't get in the court record.
Yeah.
You know, we gotta have some base to locate it in, okay?
Thank you, Judge.
See y'all at 3 o'clock then. Okay, McClendon versus Hall. Is that correct? That's the correct call?
You already called that.
Called that one, Judge.
Public finance.
Yeah, that's it. Republic Finance versus Huff. Anybody here on Republic Finance?
Oh, I'm sorry, Judge, that's mine. William Rich for the plaintiff. That's a motion for summary judgment. The answer that was filed neither admits nor denies the allegations of the complaint. I believe there's no genuine issue of material fact.
Well, I'm looking at your affidavit as far as attorney's fees. Obviously, you didn't travel to or attend the motion for summary judgment. Correct?
I would agree, Judge, yes.
Okay, well, we'll delete that $625 there. That would bring your attorney's fees. Let me say like $1,400 attorney's fees and submit the judgment, okay? Okay? Hello?
So you need us to submit a new order, Judge?
New order with $1,400 attorney's fees. Was back out that summary judgment. Attend hearing there and I'll sign it, okay?
All right, very good, Judge. Thank you.
Thank you. Thank you very much. Dyson versus Oostburg.
Good afternoon, Your Honor. Phil Dyson.
Yeah. I've gotten this out of order again. It's not the same. Here it is. What do we have here?
Your Honor, I've set a motion to set for trial. This is the third time I've been in front of you. You've ordered discovery to be produced. It hasn't been produced now twice. So let's just get a trial. You said I could come in front of you and get a trial date. So here I am.
What do we have, Mr.
Judge, it's attorney fee dispute from California that he's trying to domesticate the judgment. And I did submit the answers to interrogatories.
You speak up just a little bit.
I did submit the discovery and he said he wanted to take my client's deposition. And I said, tell me a date you're available. And
Your Honor, I don't want to get in a disagreement contest here with Mr. Stevens. I just want to get a trial date, which you said I could get from you at this hearing.
Well, you say I said that. Maybe you misunderstood me. So you're not going to run my court, okay?
I'm sorry, sir. I'm not looking to.
Let's just do it. We might as well have a trial.
Yeah.
You have no problem with a trial.
No.
You want a bench trial or a jury trial, sir?
Jury trial, Your Honor.
Okay, let's schedule a date. Now, have you prepared instructions? You need to prepare instructions and a witness list. Both of you need a witness list and instructions. And we'll need to have a trial memorandum on what your theory of the case is. And your theory is that this person owes you attorney's fees. That's your only theory, right?
That's correct, Your Honor.
Okay, so you do that. How much attorney's fee are we talking about?
It's about $30,000.
Okay. Well, you got your calendar with you, Mr.
I do, Your Honor.
Okay. Let's see here. How far out do you want it? How far out do you want it, sir?
Your Honor, I'd like it in the latter part of October.
Okay, I'll look at October here. How about October the 16th?
Your Honor, I'll be at a wedding for my daughter then. I was looking at the 26th, if at all possible.
How about the 23rd? Or let's look at the 27th. No, go back to the 23rd. Or the
23rd.
The 19th, how about the 19th? Let's look at the 19th.
Again, I'm at my daughter's wedding, Your Honor, through the 20th. The 23rd is fine. I can make that work.
Okay, let's do the 23rd.
Your Honor, will we be picking the jury that day?
We'll be doing everything that day. You can get a list of jury questionnaire forms by contacting the circuit clerk's office with the personal information on the members of the jury.
Judge, I would ask to be excused from jury duty for that day.
You are excused. We could have an exchange witness list here in 10 days from today and have jury instructions that you want to submit within 10 days as to what you think the proof is going to be and what we have to find, okay?
Thank you, Your Honor.
Okay, that's good.
When would you like the memorandum, Your Honor?
Can you have it to me within 10 days?
That'd be fine.
And you were,
I need a little more time than that.
okay, let's make it 15 days.
Okay, thank you.
15 days, okay? Okay, thank you all a lot.
Thank you, Your Honor.
Yeah. Okay. McClendon,
Go back to David, sorry, very personal.
Davis versus Adams, we'll go back to that. And then we're on McClendon after that, is that correct, Meg?
Your Honor,
Okay, you have anything to report?
I do, Your Honor. We have reached an agreement.
Okay, recite the agreement.
Yes, Your Honor. My client, Miss Jerica Davis, is going to have sole custody of the minor child, Jet, I believe Adams, who is 5 years old. The respondent, Mr. Adams, will have visitation, which is supervised by Patricia DeWolf or another agreed upon adult from 4 to 7 each Wednesday and 12 to 5 each Saturday. In addition, he's going to get 4 hours of supervised visitation on holidays, including birthdays, Christmas, Easter, Thanksgiving, and the 4th of July. Each party is going to submit to a hair follicle drug screen by August 28th and will exchange results with the other and file them as appropriate. In addition, the parties are going to communicate about the child through a parenting app. They will agree on which one by the end of this week, and they're agreeing to entry of a parenting conduct order, just a standard parenting conduct order. And we've reviewed the terms of what is included in that. Mr. Adams has agreed to pay $120 per month for child support, in addition to splitting costs of extracurriculars for the child and medical expenses, which are not covered by insurance. As part of that, my client. Yes, and my client has agreed that, excuse me, the parties have agreed that my client will claim the child for tax purposes each year.
Okay, is that what you agreed to? I mean, you need to tell me, is there something there that you didn't agree to?
Yeah, that's right.
Okay.
Yes, Your Honor. And I will get that typed up and have the party signatures and tendered to the court.
That'll be fine. Thank you.
Thank you, Your Honor. That concludes my business. May I be excused?
Yeah, absolutely.
Thank you.
Now we're going down to the McClendon, is that correct?
Already done that.
You what?
Already done that.
Well, I don't know how I've called it twice, 3 times now.
That's when they come up and they just ask if they come back next month.
Yeah, Paige.
Already done that.
Well, I was going through the books. Okay.
I believe everything else left is confidential.
Do you have something else?
Sir, I just want to report to the court.
Okay, go ahead.
Sir. Ms. Crowe, you come up if you need to. Your Honor, we, saw out there talking and stuff, and being former military myself, I understand that there may be some, you got some VA compensation money that's coming into the bank account, so there may be some exemptions there that he wasn't aware of, so, and then some credit for what has been garnished, so I don't have the full figure of what the balance is right now with all the credit stuff given. So, but both sides are willing to negotiate and work it out, so I'm gonna go back and get the true balance, and then we're gonna go from there.
Okay, well, y'all just keep me informed and everything.
Sir.
Did you hearing awesome military?
Yes, sir.
You're not an artillery guy, were you?
I was a combat engineer, Your Honor.
Yeah.
I was out there looking for roadside bombs most of the time.
Yeah, well, it doesn't take but one of them, does it?
Negative, Your Honor.
Yeah.
Just one.
Okay, thank y'all very much for working on it. We'll get those.